brought it to somebody, he was the one.
What you doing the last time you were down? I mean,
Okay, we're gonna start the meeting, so if probably no talking would probably be best, just because of the, sorry.
Is everybody muted?
They should be, and you can make sure, you can tell them to make sure they all are muted and remain muted until you instruct. What, who's got feedback? What's going on?
Are we good to go? We live?
Yeah, I'm on.
Hello, everybody. We're going to call this meeting to order. We'll call it to order at 7:02. Before we get started, Ralph Williams has kindly agreed to be the do the minutes for the meeting. So thank you, Ralph. Appreciate that. So we'll get started with the roll call. Dean Hills here. Doug Stebbins. Can you hear me, Doug?
You'll have to unmute themselves when they speak. You can, one second, Doug, you can unmute yourself when you speak.
Yeah, if you need to speak, you can unmute.
If you need to speak, just unmute yourself.
All right, so Doug is here. Joe Marinaccio.
I'm here.
Susan Peck. Absent. Andy Rocket. Absent. BJ Farrow. Absent. Dan Thayer.
Present.
And Ralph Williams. Ralph, are you here? Okay, Ralph is here. All right, before we get started, I would like to entertain a motion to change the order of the agenda to the following. Public hearing, application number 20-0001. Public hearing, discussion decision, application number 20-001. Public hearing, application number 20-0004. Public hearing, discussion decision, application number 20-0004. Public hearing, application number 20-0002. Public hearing, application number 20-0003. Public hearing, discussion decision, application number 20-0002. Public hearing, discussion decision, application number 20-0003. Do I have a motion?
So moved. Dan Thayer.
Motion by Dan Thayer. Do I have a second?
Motion by Joe Marinaccio.
Pardon? Who's the second? Doug Stebbins? Okay. Any discussion? All in favor?
Aye.
Aye. Opposed? Motion carries unanimously. So we will begin with public hearing application number 20-0001. And, Ralph, I have a copy of the motion that I will scan up and send you tomorrow morning, so you don't have to write all that down. We'll begin with 001. We'll read this into the record. Application number 20-0001, Paul Maillot, 154 Hall Hill Road, Somers, Connecticut, seeking a variance from section 214-98 of the Somers Code concerning front yard setback requirement of 50 feet to construct a 4-foot by 4-foot front porch 41 feet from the front property line in the A1 residential zone. Before we begin the presentation on this, we need to know that there was proof of notification of abutters.
Actually, I notified all of the abutters for the
Okay.
applications because of the
Jen?
executive order.
Jen has notified all the abutters, so we're good there. Is there anybody in the audience that has anything to say about this application, would like to speak for the record? If you do so, please unmute. Going once, going twice, going 3 times, sold. We'll move on to the presentation. Who will be presenting for Mr. Maillot? If you are free to go. Uh-oh. Got some, Paul, we got some feedback issues. You there?
Sorry about that.
Oop.
Let me see if I can see it.
Might be if he's watching the stream.
Do you have both your phone and computer on?
So, I'm just looking to, put a landing on the front of the house. In doing so, I thought putting a little bit of a porch, it's not extending it any farther than the landing would be. It would be uncovered, just form of a deck. Just allow a storm door to be put on the house without it swinging into the stair system. I know that you have a 50-foot variance right now, and I'm at like 41 feet. So minimally, I think I'd be able to put a 4x4 variance landing there just to allow a storm door to be put in. I'm looking to put it across the front of the house to allow for a sitting area.
Okay. Anything else you'd like to?
No, that's it.
Any questions from members of the board?
I'm gathering that because you're already at 41 feet, that this is a non-conforming lot?
It is a non-conforming lot. The house is, I think, 45 feet. I'm only looking for a 4-foot variance to allow for the landing, so I'd be able to put a storm door on the house. Wouldn't change anything if I were to put the landing on.
Yes, let the record reflect that this is a non-conforming lot. Any other questions? That's it? Okay. We're going to close the session. We're going to move into the public hearing discussion decision for this application. I would like to have a motion to approve application number 20-001, Paul Mailot, 154 Hall Hill Road, Somers, Connecticut, seeking a variance from section 214-98 of the Somers Code concerning front yard setback requirement of 50 feet to construct a 4-foot by 4-foot porch 41 feet from the front property line in the A1 residential zone. Do I have a motion?
Dan Thayer, so moved.
Dan Thayer moves. Do I have a second?
Doug Stebbins, second.
Doug Stebbins seconds. Discussion? No discussion. All those in favor?
Aye.
Aye. All those opposed?
Aye.
Any opposed? Motion carries unanimously. Your variance is approved. Jen will put a legal notice in the paper as soon as possible. I believe it would be by Friday, right? Once the notice is in the paper, Paul, there's a 15-day period which people can, object or appeal the decision. And once that time is done and there's no appeal, then you are good to go and you can go apply for your permit. So you are all set.
Excellent, thank you very much.
All right, very good. Have a good night.
You too.
All right, thank you. Okay, we're going to move on to public discussion of application number 20-004. Jeffrey, I'll read that into the record. Application number 20-004, Jeffrey Cooley Construction LLC, on behalf of Dale and Randy Brockway, 247 Mountain View Road, Somers, Connecticut, seeking a variance from section 214-98 of the Somers Code concerning front yard setback requirement 50 feet to construct an 8-foot by 28-foot front porch 31 feet from the front property lines in the A1 residential zone. Has proof of abutter notification been given of the abutters?
Yes.
And Jen says that that's been given. Does anybody in the audience have anything to say with regard to this application? Okay, that being so, board members, do you have any questions?
Well, once again, I was wondering about the nature of the lot. Are you currently 50 feet back, or is it a non-conforming lot?
I would say that it's a non-conforming lot also. I believe the front of the house is approximately 45 feet from the actual road.
Yeah, Ralph, I think to answer your question, I think the lot, it would be conforming in size, but it was, the building is non-conforming from when it was built. It was not built during today's code, so it's technically not a non-conforming in that regard, so. Any other questions?
Yeah, Gary Wysocki to the east, we're the abutters. I have no objection to this application of the Brockways adding on that front porch.
Let's see, Gary, your last name was again?
Wysocki,
Saki, and your address?
265, 257 Mountain View Road. I believe 257 abuts the Brockways.
Okay. Anybody else? No more questions from the board? I would like to get a motion to approve application number 20-004, Jeffrey Cooley Construction LLC on behalf of Dale and Randy Brockway, 247 Mountain View Road, Somers, Connecticut, seeking a variance from section 214-98 of the Somers Code concerning front yard setback requirement of 50 feet to construct an 8-foot by 28-foot front porch, 31 feet from the front property lines in the A1 residential zone. Do I have a motion?
So moved.
Second, Dan Thayer.
Moved by Ralph, second by Dan. Any discussion? All those in favor?
Aye.
Aye.
All opposed?
Aye.
I'm going to abstain on this one because I have a financial relationship with Dale. So, the motion is carried 4-0. It's approved, and I'll abstain. So Dale, same thing with you.
Yeah.
She has to Jen will run a legal notice in the paper. It should go in on Friday, but once that's in the paper, there's a 15-day period, and then after that, you're good to move forward on your permits.
Sounds great.
All right.
Thanks very much.
Okay, thank you.
All right, have a great night.
Good night. Okay, we're going to move along to discussion of application number 20-002. I'm going to read that into the record. Application number 20-002, Amy L. Eastman, 40 Hadley Lane, Somers, Connecticut. Appeal of cease and desist order issued by Jennifer Roy, zoning enforcement officer, and variance from section 12, earth removal and filling in the Somers zoning regulations in the A1 residential zone.
Mr. Chairman, for the record, I think it would be most efficient if we were to have one public hearing for all 4 applications. So if you could read the next one also into the record, we could open up the public hearing.
Okay.
And then toss it to the applicant's attorney. When it comes to the end, and if you were so inclined to vote tonight, you would have 4 separate votes, but...
2.
4.
Okay. Oh, okay, yeah, okay, gotcha.
Yeah.
Well, can we just have a little clarification on that? Because, in the way I'm reading this, the appeal of the cease and desist and and variance is in one. So those are voted separately?
Yes, so
Okay.
so if you overturn the cease and desist, they may not need the variance and you wouldn't have to act on it.
Okay, very good. All right.
But you vote on the cease and desist on each one first, and then move to the variance applications,
All right.
if need be.
Thank you. All right.
Could you remind the members of the commission, of the board, that they need to state their name every time they speak
Okay.
first?
Yep.
Because it's moving.
All right, let me read the other application into the record. Application number 20-004, Application number 20-003, Amy L. Eastman, 42 Halley Lane, Somers, Connecticut. Appeal of cease and desist order issued by Jennifer Roy, zoning enforcement officer, and variance from section 12, earth removal and filling in the Somers zoning regulations in the A residential zone. Okay. Before we move forward on this in the public discussion, a couple of things. Board members, whenever you have a question or want to speak, make sure you say who you are. As far as the public, we want to hear what you have to say. I would ask that you keep your speeches as short as possible in length. Please do not belabor the same point in different words. If somebody makes a point and it's the point you wanted to make, write down their name, and you can get into the record by stating your name and address and concurring, saying you concur with that person who spoke before. Let's try and keep the speeches to a minimum and not belabor the same point over and over. I think we should begin with letting the audience discuss.
Yeah, you mean people here in the room. For the record, Carl Andolina. I would suggest you start with Mr. Parks, who represents the applicant, and let him make his presentation.
Okay, that's fine. Is the board good with that? Okay.
Yeah, that's fine.
All right, John, would you like to make your presentation, please?
Should I approach?
You may approach. Stay 6 feet away.
I'm distributing a summary that I'm going to actually read from.
Speak loud, though, because, thank you.
For the record, John Parks, representing Amy and Dan Eastman, and I'm reading a document that I've just handed to the town attorney, the board's attorney, the zoning enforcement officer, and your chairman, entitled Eastman Appeals of Cease and Desist Orders and Application for Variances. Single hearing for cease and desist orders on the 2 lots, 4 individual decisions, cease and desist order appeals and variance requests for each of 2 lots. Simultaneous appeal of cease and desist orders and variance requests enable the ZBA to fashion a resolution that best fits the need for all the stakeholders that include the town, the neighbors, and the property owner. If the appeals of the cease and desist orders are granted, that ends the matter. The property owner could proceed with the excavation. If the ZBA decides not to grant that appeal out of concern perhaps that it would create a precedent, it also has available the ability to grant very specific, narrowly tailored variances that affect just 2 lots and have no effect on the current zoning regulations. The variances can be conditioned to provide full protection for the town and the neighbors. As will be shown, the variances requested are a classic case of practical difficulty and unnecessary hardship, and fully supported by the facts and the law. A compelling case for variances is made as to these lots. That's the introduction. Next, there is a section entitled Factual Background, and for that portion of our presentation, I would like to turn the chair over to Jay Ursery from J.R. Russo Associates, a surveyor.
I don't know if the camera's gonna get.
Yeah, I don't think how well they're gonna be able to see this, but we'll try. For the record, J.R. Street, J.R. Russo and Associates here representing Amy Eastman with regard to this application for appeal of the cease and desist and variances of the regulation. And I'm going to talk a little bit about both properties, which are located at the end of Halley Lane. We've got two parcels, the house parcel and the rear parcel land, one located in the A1 zone, the house, and the rear parcel located in the A zone. In terms of acreage, the house parcel, the front piece, which is located, those of you members who have your plans, we're looking at sheet 1, which is the overall plan. House located here just off of Haley Lane, a winding driveway that comes up the hill to the house itself. And the rear land, a little over 40 acres, fairly large in size, a good sized portion here, and then it winds around over to the north and the west, and we've got a large parcel of land located over in this area. I've got highlighted here in green crosshatched the area of the excavation. It's a little larger than 1 acre in size. It's about 1.1 acres. That's actually identified on your plan set, and that acreage is called out. There has been some excavation work that's been done there. I was first at the site last fall, I believe. I don't remember exactly when, but there had been some work done prior to that, I believe. But I was there last fall. I've been there numerous times since then. And I'd like to submit for the record here a recent aerial that was taken last week, actually. I think it was Thursday the 6th. And I've got multiple copies. I don't know how well you're going to be able to see that. But basically, what this shows is an overall view of the area of the excavation that's located behind the house. And what we actually have here is a house location that's at an elevation of a little over 600 feet. And we've got an area of rock outcropping that's directly adjacent to the north and the east of the house and the driveway that jumps up about 22 feet at its highest point above that floor elevation of the house. So there's a substantial increase. I think there's some photographs in your materials that Jen had that actually depict it very well. When you see it and you look out, you basically walk off the end of the driveway adjacent to the garage, and you essentially walk right into almost what you would call a rock wall. So it's essentially, due to the rock and the topography, it's pretty much unusable, that portion of the yard itself. The excavation that's gone on over the last number of maybe years or months, I'm not even really sure, to be honest. And I'm going to flip over to page 2, so those of you who have plans can move with me. And here we're going to have a blow-up of the area directly behind the house, again with some highlighting, and I hope you can all see this. And what we're showing here is, again, the house lot portion here. This is the house. This is the outside total area of excavation. Here is the zone line and property line. So we got the 5 acres, we got the 40 acres back here. This area that's cross-hatched here in the orange hatching is area where essentially the excavation is complete. So it's just about done. In fact, it may be now, because they've been working a few more days since this was done. They're just about done up to the zone line. So for all practical purposes, the area on the rear portion of the property, which is the A-zone portion, the excavation is pretty much complete. There are various stockpiles of rock that are located back here. Some of the rock has been placed here on the slope as shown on the grading plan. No rock has been hauled out to the very rear yet and placed out there. So right now all the material that's been taken out of here is stockpiled here in the back. So there's an area here in the front that's remaining to do. Most of that area is within the A1 zone, and my understanding is if they go with the hydraulic hammer on the excavator, which is what they've been using, that it's probably going to take 3 to 4 months to complete that. versus blasting, and I think you have some reports in your memos that indicate that the blasting would be much more efficient, a lot less time-consuming, and quite honestly, probably less disruptive to the neighbors in terms of noise. The blasting certainly would not happen every day versus the hammer that's running pretty much all day, every day. It doesn't stop. It's a very tedious process, takes a lot of time, versus the blasting, which would be infrequent over that amount of time, and the noise from the blasting would be substantially less than the noise from the hammer. So those are some things to think about. In terms of the actual variances that we're talking about here, and what we're really are looking at is topography. Essentially, the rear portion of the area here immediately behind the house, which most of us would probably call our backyard, is unusable. It's just steep, rocky, really not usable for anything. Typically, you would think you'd like to go out in the back and maybe play ball with the kids, soccer, football, whatever. That's an area there that you're probably going to stay away from, because it is actually probably even a little dangerous right now. But the idea is here that we're going to grade it down and create a nice large lawn area, an area that the kids could play in the backyard, which certainly I remember as a kid playing baseball and so forth in the backyard of my dad's house. It was a lot of fun. Here that's going to be a little more difficult with the topography and the rock outcropping that's there. So that's a basic overview of the property, what the proposal is to complete the work, and as we move forward, if anybody has any questions, I would be happy to answer them for you.
Actually, I have a couple of questions. Carl Landolina. Jay, would you describe what happens to the material once it's whatever?
The proposal here is to, and if you look at the topography here, there is an area here that was done, I don't know, a couple of years ago maybe, where the rock has been placed on the side. There's a access road behind it. Well, that's going to continue in this area here. Rock will be taken from here, moved over here. Right now, the area that has been excavated here, the material in this area is just being stockpiled. The original proposal, I'm going to go to the front sheet again, sheet 1, where we can see everything, was to place the rock back here, taking it down an old, essentially logging road, and coming to the rear of the property.
This is not a zoning meeting, this is an appeals meeting.
I think that answers your question, I believe.
I'm sorry, I got interrupted.
So
you're going to move it to that?
It's still an appeals meeting.
That's what we're discussing, evidence.
No, you're discussing the zoning part. This is specifically about appeals, about a cease and desist.
All right, I haven't recognized you to speak yet, so when I do recognize you, you'll have your turn. But until then, I'd like to ask you to be quiet. Thank you.
So again, placement of material in this area and placement of material in this area to the rear from the excavation that's located here. Nothing leaves the property.
My last question for you, I guess, was maybe John can speak to this. How long has Mr. Eastman or Mrs. Eastman owned the property? It's Carl Landolina, for the record.
05.
15 years?
05.
Okay.
Maybe I'm woefully unprepared, but could you just explain why do you need the variance?
I have prepared, after Jay is done, a portion of my summary that addresses both why we appealed the cease and desist and why we need a variance.
Very good.
But the timing had a lot to do with it, because since the applications were filed, things have happened. So it's not exactly the same situation today as we sit here, as it was the day that this was filed, similar to what, Jay is describing. It's been an ongoing process.
Okay, thank you. Anything further here?
I don't have anything else to add at this point.
Okay, we will now open this up for the public comment.
I haven't finished yet.
Oh, I'm sorry, never mind, excuse me. John, go ahead.
So, just as indicated on my summary, I did an introduction. Now I'm going to address in two sections the appeal to cease and desist and the variance application as stated would be on page 2 of the summary that I'm the introduction and Jay is the second speaker.
Okay, very good.
For the record again, John Parks, reading from the Eastman Appeals of Cease and Desist Order and Application for Variance document that I presented at the beginning. Under the section Appeal of Cease and Desist Orders, there's just some bullet points. Interpretation of the regulation, February Town Attorney's opinion, later discovered evidence of the interpretation of the regulations, strongly believe his opinion would have been otherwise had the evidence been available back in February. Excavation, removal, and filling have only been interpreted to apply in the commercial context. Never has a private residential lot where no material was sold off-site. Affidavits of Patrice Carson and Jay Ursery and Dwight Merriam's opinion, later based largely on those affidavits, speak to the fact that the regulations do not apply to this rock removal activity. Moving on to the section entitled Variances, all that is needed to complete the work that is 60% done are variances of the 1,000 cubic yard exception for the two lots. 40 Halley is the Eastman's 5+ acre lot with their home. If it were 5 1-acre lot, there would be 5,000 cubic yards of exemption. They need to break up 9,630 cubic yards. The lot meets tests for practical difficulty and unusual hardship given the unique rock ledge, a pre-existing condition. 42 Halley is over 40 acres were it a subdivision, that there would be 30 lots, each with 1,000 cubic yard exemption, a total of 30,000 cubic yards as of right. There is less than 1,000 cubic yards remaining to be excavated, and thus the lot needs no variance to complete the work. All that is needed is a variance of an exemption of 9,000 cubic yards after the fact for the rock already excavated. Application for variances and the supplemental memorandum describe practical difficulty and unnecessary hardship. This is a classic and factually and legally compelling case for variance of the 1,000 yard exemption. Those two things mentioned were, what I emailed Jen this morning, and I saw that she handed you earlier, which is the supplemental memorandum. Conditions. The extensive conditions are proposed to fully protect the town and the neighbors. The only possible impacts of the rock excavation are soil erosion and sedimentation, wells, and noise. Turning now to the third page. As construction activity, the work is exempt from noise regulation under the local noise ordinance and the state regulations. The wells will not be impacted, and if there are any claims, a bond is proposed to cover claim damages as determined by a court, and soil erosion and sedimentation controls are in place and will be maintained. For my conclusion, the appeals of the cease and desist orders should be granted based on the recently developed evidence of a pattern and practice of the town to apply the excavation, removal, and filling regulations to commercial mining only. If the cease and desist orders are not overturned, the facts present a classic case for very limited variances of just the exemption limits for these unique situations where there is clearly demonstrated the practical difficulty and unnecessary hardship that precludes reasonable use of the residential property. Before coming here today, I did look at the website for the town, and under your website, I believe posted by Jennifer Roy, are several documents which are before the board by virtue of her posting it, and one is 40 Halley Lane, .1.2020, 42 Eastman site plans, which are the equivalent of what Jay spoke of, and ZEO recording documents dated 6.9.2020 hearing. If you click on those, there's a number of documents within them viewable from the town's webpage.
May I ask a question, Attorney Parks?
Yes.
State your name.
State your name and address, please. Who is this?
The
Ron
state-
Williams.
Oh, okay.
I'm a member, I'm the alternate of the ZBA.
Yep.
You mentioned that 60% of the work is done. Has any of this work been done since the proof of desist order was issued?
Yes.
So you actually have been acting in either disregard or defiance of the lady?
No. The order was to cease and desist or to appeal, and we chose appeal.
Interesting, okay.
All right, do you need to present?
I have a few questions for Mr. Parks, if I might.
Absolutely.
Attorney Landolina. So, Attorney Parks, with respect to 40 Halley Lane, that's located, I understand, in the A1 zone?
Correct.
Do I have that? I get those two mixed up.
Yes, correct.
And what is, if anything, preventing you from applying for a special permit to conduct this activity on that lot, since it seems to be allowed by special permit under the regulations?
I think, the answer is, and I'll rely on the memo, but I think the answer is that this landscaping, project in the backyard of a house in an A1 zone does not and never has required a special use permit. I think that was always used, and by the way, I've been practicing law in the town of Somers for the last 41 years and have attended earth excavation renewal permits, subjects of special use permits annually, starting with the wood gravel bank, and that is my experience in 40 years or 41 years of when special use permits for earth excavation are needed.
All right, with respect to 42 Halley Lane, essentially, you're saying right now there's less than 1,000 cubic yards remaining, so the lot needs no variance to complete the work. All that is needed is a variance for an exemption of 9,000 yards after the fact. In other words, you're looking for a retroactive variance? Would that be fair to say? You're saying after the fact. I assume retroactive is, I would think, one word which encompasses after the fact. I don't know. Well, you don't have to answer. I'm just pointing that out. I'm just trying to understand so that the commission can understand what it is exactly you're asking for. In other words, you're not saying you're going to withdraw your application for a variance on 42 because there's less than 1,000 yards left. You're still looking for a variance, but you want it to encompass all the earth or the rock that you removed in the past without a special permit or variance or whatever else might have been needed.
I believe, Attorney Landolina, that the argument is in the alternative. One, that the cease and desist should be denied, and the second and probably creative argument that you are questioning me on is an option before the Zoning Board of Appeals in this extremely unique case, if I understand that question.
I think my last question right now would have to do with your statement, or the statement in this memorandum that 42 Halley is over 40 acres. Were it a subdivision, there would be 30 lots, each with a 1,000 cubic yard exemption for a total of 30,000 cubic yards as of right. Is there any evidence that this piece of land could be subdivided in its current condition? In other words, is there a way to get to that back property? How likely is a 30-lot subdivision back there?
My experience is, due to the topography and the configuration, unlikely. I think that was an example of, I think that was a comparison, but this property, from my years of practicing and my knowledge of your planning regulations, would have slope issues under your I'll call it your subdivision regulations. And I have no idea about wetlands back there. I did not see any, but that's another factor. I think it was an analogy. That's what
so
I
if
think.
this land was subdividable, and you took
if
that
it was,
acreage and...
I think that's
Okay.
the argument.
All right. I didn't know if you're specifically talking about this piece of property or just hypothesizing about any 42 acres anyway.
I'll go with hypothesizing.
Okay.
Big word.
Yeah. I struggled to get that one out. That's all I have. Thank you.
Okay.
Thank you, Carl. All right.
And I would just, again, for the record, Attorney Landolina, I take no position on this. This is your decision. I have no interest whatsoever. I just want to make sure that you have all the information that you need to make an informed decision. That's all. Thank you.
Thank you, Carl. Okay.
John, maybe he can go to the microphone.
I apologize.
Again, for the record, Carl Landolina, I just want to correct something. I think, I'm not sure which of the two previous speakers said it. Mr. Ziska, Attorney Ziska, who's about to speak now, represents Jennifer Roy in her capacity as zoning enforcement officer. I represent the board. And I think that might have been stated incorrectly earlier on. If it wasn't, I apologize, but if it was, just clearing up the record.
Thank you.
Sorry, Mike.
Okay. For the record, my name is Michael Ziska. I'm a lawyer with the firm of Halloran and Sage. Just so that the ZBA has some familiarity with my background, I've been practicing law since 1982. The vast majority of my practice has been in the area of municipal law and specifically land use law. The vast majority of my clients have been municipalities and municipal commissions. Over the course of my career, I've represented over 60 municipalities in the state of Connecticut, so more than a third of the towns in Connecticut have been my clients at some point or another, or at least their commissions have. I am the author of a book that is, and I'm not patting myself on the back, just so you know, is one of the most widely used land use manuals in Connecticut called What's Legally Required. I'm also the principal author of a national treatise on land use law and liability that has been published, oh boy, I can't even remember anymore, I think sometime since the 1990s, in which I update every year. So I'm coming to you with that background and experience. I certainly am familiar with all of the players and respect all of the players, Attorney Merriam, Attorney Parks, Attorney Landolina. When I was asked to participate in this hearing, my goal, as always, was to give my opinion without regard to what that opinion would be. In other words, I didn't come into this saying I'm going to render an opinion that's favorable to Jennifer Roy or to the Zoning Commission. In fact, the way it was approached, Attorney Landolina at one point contacted me and just said, "What do you think? Am I off base here? Is Jennifer off base in the cease and desist order?" So I looked at the regulations, I looked at what was going on, and I said, "Far from it. Far from it. No, so I have no axe to grind here. If I thought Jennifer was wrong, I wouldn't be here, because I would have told Carl that, and I wouldn't be here. I would have said I can't stand behind the cease and desist order. And in fact, just so you know, I'm winding down my practice. I'm not actively looking for more clients, so I'm not, that's not the reason I'm here either. Now, with that background, I have to say, it's generally the duty of a lawyer who's advocating for a client to put the best face on what they're doing. And I think that's what's going on here. But I have to take extraordinary issue with Dwight Merriam's letter. I think Dwight's letter in this particular case is so full of gaps and inconsistencies and errors that I'm astonished by it, frankly. And here's what I'd like to say first of all is, I think it's helpful for you to understand where I'm coming from in looking at your zoning regulations, because that's where we have to start. Part of the issue that's been brought up here is the interplay between the schedule of permitted uses, which is in section 214-98, and the earth removal and filling materials, which begin at section 214-66 and is part of Article 12. The important thing, I think, the critical thing to look at is, if you're looking at section 214-98, the schedule of permitted uses starts with primary uses. And that is what is absolutely critical about that. primary uses. A primary use is the major use that's occurring on any particular site. So if the only thing that's happening on a site is earth excavation, then that's the primary use of the site. Now, in Mr. Landolina's letter, as I understood it, he said he was looking at earth removal, which is number 7 under the schedule of primary uses, and he said that's not allowed at all in an A zone. And that's correct. It is not allowed at all in an A zone as a primary use. One of the problems I have with Attorney Merriam's letter, though, is he tried to make it sound as though nothing is allowed. No type of earth excavation is allowed in an A zone if you follow Attorney Landolina's letter, and that's not what he said, or at least as I understood it. What he was saying is you can't do it as a primary use, and since the only thing that was going on 42 Halley Lane in the A zone was earth excavation, that's the primary use. And Attorney Landolina is correct. It's not allowed as a primary use. However, if there were another use of the property that were going on, for instance, if 42 Halley Lane already had a house on it, then it would be possible to come in under Article 12 and ask for a special use permit to excavate more than 1,000 yards, provided it meets one of the requirements that's set forth in the exemptions in Section 214-68. And so I agree with Attorney Landolina, and specifically the comment tonight, that that's the approach that should have been followed. It's disappointing, having looked at the record, to find that there were in fact applications to the Zoning Commission and that they were withdrawn. There is a principle in law that's called exhaustion of administrative remedies, and where you have a remedy that you can exhaust, where you have the ability to get something that you're looking for, even if there's a claim about whether you're legally entitled to it, you can be asked to appear before a commission to make your case why it should be allowed. If it's not allowed at that point, that's the time to come to the ZBA for a variance. So that process wasn't followed here. They never went to the Eastmans never went to the Zoning Commission to follow through on that. Now, again, if the Zoning Commission had said, we don't think you can do what you're doing, then they would be entitled to come to the Zoning Board of Appeals for a variance. But bear in mind, what Jennifer Roy did not say is that you don't have the right, she did not say you don't have the right to excavate earth under any circumstances. She said what you're doing right now is in violation of the regulations because it has not been properly permitted, and that is correct. And just as a side note, I have to take exception to what Attorney Park said tonight. He said that the order said either cease and desist or appeal. It plainly did not say that. It said cease and desist. And like almost all cease and desist orders that I've ever seen in the state of Connecticut, it said, by the way, if you want to appeal this cease and desist order, you can do this. But it did not say, if you appeal, the cease and desist is off, and you can do whatever you want. That would make no sense to interpret it that way, and that's not what the order said. So, the way I look at it is there is an opportunity under Section 214-68, the exemptions, to get a permit for the excavation of over 1,000 cubic yards. Now, I want to be clear on this. There could be some quibbling about that. The exceptions that are stated are not as clear as they might be, and there could be some quibbling about them, but I think the Zoning Commission in the long run has, certainly has the right to hear the application and to decide how it wants to apply those particular regulations. And that's not a decision for Jennifer Roy. That's a decision for the Commission to make, how to apply the regulations if an application is submitted. But I would point out that the exemptions include A, bona fide construction or alteration of a structure for which a zoning permit or special use permit has been issued and the amount of material to be removed or filled has been approved by the Commission. B, the landscaping of a lot having one or more existing structures. That sounds to me, and again, this is just me, but that sounds a lot to me like what we're talking about today. That we're trying to make the lot usable by I suppose, what you could broadly call landscaping. And there's also an exemption for a bonded or otherwise secured subdivision approved by the Planning Commission. So in fact, if the applicant wanted to develop 20 lots, 10 lots, however many lots from those properties, the applicants she would have to go into the Planning Commission with that application, and she would have to demonstrate at that time that the removal is appropriate and that it's being done in conformance with environmental standards and community standards to protect the community. One of the things Attorney Merriam said in his letter is Section 214-66 doesn't mean anything because it's what he called precatory, which just means it's a statement of ideals. It doesn't really mean anything, and that's absolutely wrong. Those purpose statements give meaning to what the rest of the sections talk about. And this says the purposes of this article are to preserve a cover crop on the land, to prevent erosion, and to control any excavation or filling operations that may create a safety or health hazard to the public or the nearby property owners, or be detrimental to the immediate neighborhood or to the town of Somers. So you would have to ignore that in order to assume that excavating over 1,000 cubic yards of rock is not covered by the regulations. That's nonsense. Of course it's covered by the regulations. The statements that, well, we've always called that kind of thing a gravel permit, so therefore it can't apply to that. The thing is, if the applications that are coming in are for excavating gravel, they're going to be called gravel permits. If you've never had an application for a quarry, you might never have had to deal with this situation. So this is a quarry. When you're excavating rock, it's a quarry. If people have come in for sand and gravel excavations and gotten permits, that's a completely different thing. That's apples and oranges. This is a rock excavation of over 1,000 cubic yards. Unless you can show that this zoning board of appeals has interpreted the regulations to allow that without any kind of a permit, there's no historical precedent. That's another argument that I'm disappointed about in Attorney Merriam's letter. He says you should be estopped, or Jennifer should be estopped from enforcing the regulations because of this history. There are several problems with that. One is, again, the history is for sand and gravel permits, not quarries. Second, the interpretation has to come from the Zoning Board of Appeals, because you're the ones being asked to make the decision tonight. The past practice thing that he's talking about is, again, it's not the standard. He's not talking about the standards that are used for estoppel. He's talking about the standards that are used by a court when it's being asked to interpret a regulation for the first time. And there's case law that says, there was a case from Essex that was one of the leads called Doyen versus the Essex Zoning Board of Appeals. That was a situation where the question was, if you have a house that's located partly in the setback, can you go vertically up without getting a new variance? Under some regulations you can, and under some regulations you can't. And what the court said in that case is, there was evidence that the Zoning Board of Appeals had historically applied the same standard time after time after time, and that was, yes, you can go up. And the court said when that standard has been applied by the Zoning Board in the past, then we should give some deference to that standard. But even there, the court has some wiggle room. Still doesn't have to agree with the Zoning Board. It says, but in those cases, we'll give some deference to the board. That does not apply to a situation where a completely different type of application was involved, such as a sand and gravel excavation, or a decision was being made by somebody other than the board. A past town attorney or somebody else said, well, that's how I think it should be interpreted. Unless it's from the board, it's not only not binding, but it's not even significant to a court. So it's not a case of estoppel. The concept of estoppel, and there's lots of case law on this, the concept of estoppel requires that a person in a position of authority has misled the landowner, and that landowner has acted on that misleading information to his or her detriment. So, for instance, if Jen Roy had said, Mr. and Mrs. Eastman, feel free, go ahead and excavate all you want to, no problem. And the zoning commission said, yeah, we don't have any problem with that, and they went on, and then later, a different zoning enforcement officer came in and said, oh, no, I take a different position, so I'm going to issue a cease and desist order. That would be a case of estoppel. But here's a situation that's just the opposite, where the applicant actually is saying, I thought I had to come in for a zoning permit because that's what I was being told, and it was only until my new attorney, Dwight Merriam, told me that I didn't need one that I realized that I didn't need one. So he's being misled not by Jennifer Roy, but by Dwight Merriam. So that is not a case of estoppel, and by the way, estoppel is not something that a zoning board of appeals does, it's something that a court does, and only a court does. So, let me talk about, just for very briefly, about some of the other things I'm disappointed with in Dwight's letter. He defines excavation, and he uses Merriam-Webster's dictionary. I don't know if the Merriam and Merriam-Webster is any relation to Dwight, but he says it includes, quote, to dig out and remove. And it doesn't really say that. What it says is excavation is the process of excavating, and excavating includes that, but it also includes to form a cavity or hole in. He didn't mention that. To form by hollowing out. He didn't mention that. To expose to view by or as if by digging away a covering. He didn't mention that. All of those make it very clear that when you're taking rock away from something, you're hollowing out, you're forming a hole, you're exposing to view as if by digging away, you're doing all of those things. And even there, the one he included was to dig out and remove. But again, he says remove, when he defines remove, he notes that the definition, it says to change the location, position, station, or residence of, or a second definition, to move by lifting, pushing aside, or taking away or off. And then, right after that, he says, so you have to take it away. And I'm thinking, didn't he just read the definition that he just gave? No. You can do it by any one of those things. Lifting, pushing aside, taking away, changing the location, changing the position. All of those things are happening with this excavation. Filling, the Merriam-Webster says, is something used to fill a cavity, container, or depression. And then Attorney Merriam says, sculpting the landscape to prepare it for the placement of permitted accessory structures is not filling a cavity. Says who? Says who? That's not what Merriam-Webster just said. That's what Attorney Merriam just said. So when you're moving rock or soil or earth materials into a place that it didn't exist before, you're filling. It's common sense. That's what you're doing. And that's what the Merriam-Webster definition says. So he then goes on to argue that removal of earth products can only mean an excavation leading to the transport of materials off-site. No, not at all. Just as is going on in this situation, if you're digging out that material and placing it elsewhere on the site, you're removing it from its past location. And that's all that's required. It's being removed from its prior location. And just think about the common sense of this. Again, I point to that section of the regulations that talked about why the commission had these regulations in the first place. And it says to preserve a cover crop on the land, to prevent erosion, and to control any excavation or filling operations that may create a safety or health hazard to the public. So if you're looking at that regulation, you have to say, well, how is the impact different to the environment or to the neighbors if the material is being excavated and moved off-site versus being excavated and moved somewhere else on the site? There may be some differences. For instance, maybe you don't have trucks going back and forth down the driveway, so there could certainly be differences in those types of conditions, but to assume that the commission never wanted to look at the same kind of activities just as long as the material stays on site doesn't make any sense. What does make sense is to interpret 214-68, the exemptions, to say, look, if you're doing this in connection with another lawful activity, and we have an opportunity to look at that, what you're doing, and approve it, and put on any conditions that we think are necessary so that we can protect the public. Then you're exempt. Then you can do it. So it preserves the right to do these types of things, but you've got to go through the proper procedures in order to do it. And I think that's all that Jennifer Roy's cease and desist order is really saying. Go through the proper process. Finally, I would say, with respect to the variances, the courts have said for years that variances are not to be granted lightly. And you have to do more than come in and say, well, gee, we've got a lot of rock on our property and it's not very helpful to what we want to do. I was in the unfortunate position, I don't mind talking about a case that I lost at the Supreme Court. It was called Varillo versus the Zoning Board of Appeals. It was one of the most recent appellate court cases on the issue of variances, and it was some 71 or 72 pages long. The court went very, very thoroughly over what you need to prove to get a variance. And just so you know, the Varillo situation was one where this poor slob down in Branford had this little tiny lot, one of these beachfront communities. He's not on the beach. He's way back from the beach. He's got one of these little tiny lots. It's less than a quarter acre. All these houses crammed in together. He's got a stone foundation that's he's got his boiler in the kitchen and stuff like that. He wants to make his house a little bit bigger. Unfortunately, he's got a neighbor that doesn't like him. So he filed an application for variance because his house was already within the setbacks, and all he wanted to do was to go up a little bit, so he could add a little bit more room, get the boiler out of the basement. He wanted to jack up the house, fix the foundation, and he asked for variances to be able to do that. The board granted the variances, the neighbor appealed, and the neighbor won. And we made all of the arguments to the court about why this should be allowed, and the court struck every one of them down. And they included, look, this is, a minimal thing. They just want to make the house a little bit. The court said, no, there's not enough proof of that. The court said, all this is them wanting to satisfy their personal desire. And the court said, personal desire is not enough for a variance. You have to prove that there's something unique about your property that prevents you from using it in a reasonable manner. We said, okay, the reasonable manner we want to do this is we want to get the boiler out of the basement. We want to fix the foundation. And the court said, you already have a reasonable use. Maybe it's not what you like, but you have a reasonable use, so you don't need the variance to do that. We said, look, this house this property is unique because it's very, very tiny. The court said there are lots of tiny lots down in that area. There are lots of them. So the fact that you have this tiny lot is not unique. And now I'm looking at this and I'm saying, there's rock on this property. Well, I bet you there's rock elsewhere in Summers. I bet you this isn't the only property with rock. Do we need to remove this rock in order to make a reasonable use of the property? That case hasn't been made, as far as I'm concerned. To say that I don't have a backyard, I can tell you, when my wife and I went house hunting, we went down to Marlboro and we saw a property just like this, with a house and there was a great big rock wall in the back. There was no yard. But I got to tell you, I don't think any court's going to say the desire to have a backyard when you've built a house up against a rock wall is a reason for a variance. So variances are important. The courts have emphasized how important it is not to give variances unless there's a really, really compelling reason to do so. And here there just isn't, or at least if there is, it hasn't been proved yet. I think the applicant would have the opportunity to come back if the zoning commission said yes or said no, we're not going to grant you a permit to do this. There might be a compelling reason to come back at that point and say, okay, here's why my lot differs from other lots, and here's why it's really important for me to have this option available to them. But they haven't gotten that far yet. At this point, they've only said, well, we'd like to get the rock out from our backyard. That's not a good enough reason for a variance. So we don't think a variance ought to be granted tonight either. I thank you all for your attention, and certainly glad to answer any questions from the board.
Are there any questions, board members?
I've put them all to sleep.
None?
Not at all.
Very good. Okay.
Thank you.
Thank you for your time.
Mr. Chairman, could I make a point before we continue?
You certainly may.
I noticed that BJ
This is
Farrell
Ralph Williams.
has now joined the meeting. And so you've got 3 members and 3 alternates. And it's the chair's prerogative to decide which alternates ought to be sitting on the application. And I think to avoid any confusion, you ought to make that determination.
Yes, it would be, since BJ came on late, it will be Ralph and Dan.
Okay. All right. Enjoy the show anyway, BJ.
Okay.
Mr. Chairman, for the record, Carl Andolina. I don't know if Mr. Parks would like to respond now or wait till after the public has had an opportunity to talk as well. And
I just have one point, but I don't know if the public has, I have a point, just one point directed at, attorneys.
Please do, come on up.
John Parks again, on behalf of the applicant, and obviously, two, kind of zoning powerhouses with Mike Sitka and Dwight Merriam, and it's clearly a highly, technical area that, in terms of just citing the cases, is out of just my league, but I'm just practically looking at a house that was part of a subdivision, and then the owner bought the lot behind that is in a different zone, and the property line being the change. A practical solution to me would seem to be to just, because it's in the same name and the same ownership, if these lots were combined, then you wouldn't have that segregation. I understand that that's not the case today, but of course I didn't know that that was the argument, and I don't think I'm as smart as him, but I'm just being practical. My only point.
Anything else, John?
Nothing here.
Okay. All right, we're going to open this up to the public now. Again, as I stated before, if you wish to make a comment and you have heard somebody else prior say pretty much the same thing, but you want to be on the record, don't belabor that point over again. Just state that you concur with that other person. Make sure you state your name and address, and do try and keep your comments, your objections, or your support to as minimum as possible. But we do want to hear what you have to say. So we're going to start on the board. We're going to go from top left to right, and if you have something that you would like to add, then you may, and if you don't, we will move on to the next person. So, good. That would be
930. His phone number is 930-7894. Did you want to speak?
Yeah, and that's me, Joe Marinaccio, on the board.
okay.
Oh, okay.
We'll come back to the board after.
Okay. 352-249-7650. Would you like to speak?
I'll take it that's a no.
Muted.
Let's move on. Come back.
Okay.
Tina Fiore?
The person, the name stating Tina Fiore. Did you want to speak?
You're muted. You gotta unmute yourself.
No, you don't want to speak? No? You do? If you do, you need to unmute yourself. Fiore.
do you have the ability, this is Carl
I'm trying
Henry, to
to
unmute everybody, unmute everybody while we're at this phase. Go down to participants.
Right.
In the right should be a list of everyone, and just go at the bottom, it should say unmute all or something.
Okay, currently everyone is unmuted, so please mute yourselves. Tina Fiore, you still are not unmuted, I'm not really sure why. Do you want to speak?
I want to speak, but I'm not quite sure what unmuted means.
Okay.
On my phone.
Okay.
What's your name?
Carol Falkowski.
Okay.
Your address?
19 Root, RRROOT.
Okay.
Road, Summers, Connecticut.
All right, and feel free to speak.
Okay, well, good evening to everyone.
Hello?
My name is Carol, like I've always said, and, pardon me?
Go ahead, Carol.
Hello?
I have asked that everybody else be quiet and let Carol
I'm
speak.
just going to talk, all right? Get it over with. If nobody's here, well, I've been on here an hour. So,
No, you're not. We're gonna let Carol go. We're gonna go in order. Sorry. You're gonna wait your turn. Carol, go ahead.
Okay. Okay. As most people know in town, that I live right behind the Eastmans, 11 Holly Lane, I believe that's their address.
Okay, go ahead.
And I am fully aware and support the cease and disorder of blasting because I live in a 300-year-old house. I can almost wave across there, and I'm so afraid that because the house is so old that it's a possibility that with this blasting it could be, permanently damaged. I'm not sure, but I'm just afraid that it would be a disaster if this happens again, because the last time it happened, nobody seemed to stop them for a while. The blasting, I don't even know how they got it in here so quick, and that was a year and a half ago. And Mr. Eastman had sent a gentleman here, and he knocked on my door and he wanted to know if I would be able to sell a few pieces of land down below.
Carol, can you kind of stick to the point, please? So I take it you're opposed?
The point is, I feel that blasting, I don't support this blasting. It's deceased, disordered, and I'm not,
Okay, very good. So your point is that you oppose lifting the cease and desist.
I oppose it.
Okay, very good. Okay, we're going to move along. Okay, Carol?
And can I just say one thing?
Yes.
And to the town officials, I wish you uphold this cease and disorder against Mr. Easton. So if you can...
Very good. Thank you.
On the phone.
Thank you, Carol.
You got me. That's it.
Okay.
Thank you.
661, who ends with 6611, do you have anything to say?
I think that's me. It's Kristen Curran at 9 Halley Lane.
Hi, Christine, go ahead.
Kristen.
Oh, Kristen, I'm sorry.
I oppose the lifting of the cease and desist, and I oppose any variances being granted. The jackhammering has been going on for over 2 months, and it's been quite a nuisance to the neighborhood. But I'm also opposed to the blasting because I do believe it's had adverse effects on my property, most specifically to my water quality. We know we've seen sediment in our water, we've had to change out our water filters, and now I'm researching having a water mitigation system put in. So I'd like to not see any of this work done. I feel like it has been done unpermitted, and it should not have been allowed in the first place.
Very good, thank you. Joseph?
Hi.
You're up.
All right, so first and foremost, I do want to apologize for my outburst earlier. As you can tell, it's been a very heated topic, and I do apologize for my actions.
Joseph, can you state your name and address first, please?
Oh, I'm sorry. My name is Joseph Stigler. I'm at 159 Mountain Road.
Thank you.
So now to get to the point of this. So I oppose the lifting of cease and desist for 40 and 42 Howling Lane as well as any variances. This has been a continuous, Mr. Eastman and property have been continuously doing the jackhammering for the last 2 months without, while under the cease and desist dated April 16th. The other thing about this is that in the packet of information that was uploaded, that was available on the zoning board site, it shows in the packet that they had a cease and desist, that there's actually a different cease and desist dated September, that was never finished appealed. It looks like the appeal never went through the process. Then there is this appeal. There is also the cease and desist that occurred on April 16th. You guys have a stamped copy that was dated that it was received by Jen Roy on May 14th. However, on an earlier email that was sent out by Jen Roy, they are undated paperwork that do not have any date on them, do not have any received stamp on them. That I am curious as to why there's now a set of paperwork that has stamping on this. The point of this is throughout this entire process of going on and the, as stated before, the withdrawal of withdrawal of the special use permit, the withdrawing, and now this entire process, there hasn't been any actual actions that have happened to stop these from just doing what they want. And, while yes, over the last 2 months, there has been the continuous jackhammering, this has been a continuous problem of them just doing whatever construction that they want to do for the last year and a half, for at least the last year and a half, using an easement that is between the Clark's residence and the Roviati's residence, that is not graded for trucks. And it has just been a continuous of them doing whatever they want. Now, Mr. Ziska did state a lot of what I was already planning on stating, and I appreciate that because he did a lot more eloquently than I was able to. But the big thing about this is that with the cease and desist, there is in the state of Connecticut charter that someone violating a cease and desist is supposed to have certain repercussions and fines and potentially jail time. Now, I have asked, of course, to see any type of thing about this, but there has not been any record of any of the fines being paid or any of the appropriate time for them violating the cease and desist that have been in place since September. So I am deeply concerned about this entire process and would like to, of course, ask the Board of Appeals to take this into consideration when making their decision.
Okay.
So,
thank you, Joseph.
And like I said, that's what I have to say as far as this is concerned.
Very good. Thank you. Okay, Janet?
Hi. Yes, Janet Schlossheim, 155 Mountain Road. My property abuts the Eastmans behind my home, so they are higher up than us, and I am lower down than them. When they first said that they were going to blast, we were quite horrified. So we got our own independent civil and environmental engineers out to our home. We've also talked with Dan Eastman and been on his property. We had a pre-blast survey done because we were extremely concerned that there would be damage to my property and to the surroundings. And it was independent. It was done by us, by Dan. We had core samples taken out of the rock. There's no arsenic, there's no nitrates, there's nothing in that rock that's going to potentially poison our wells. So it's all separate labs, and it was Susan O'Neill out of Manchester, which is a huge civil and environmental engineer, because feelings, or I feel that this might happen, or, you know, so we just wanted facts. The facts came back that the kind of blasting that Dan proposes to do, if that's what he is still the same proposal from a few months ago, will have no effect on my home or my property. And I now have this survey, so if I do see something like my chimney falls down, I now have a backup plan to say, this is what the engineer said, you blasted, my chimney fell down. So it can lead directly to you, because you did this kind of blasting when you said you were going to do this kind of blasting. What he's doing is he's taking the surface of the rock off, he's not going beneath the rock. So we've looked at what happens when you blast, what happens to the actual stuff that you know, the blasting, whatever it would be, I'm losing my train of thought now. But we were concerned that it would contaminate the water, the actual, whatever they used to blast with. And it's not going to happen for us, where our property is. We've had this done, so I know this is super unpopular, but I would say, go ahead, let him blast, let's get this over with. Living with this jackhammering is horrific. It is intolerable. Like, it's all day long. You can hear it all over my home. I can't go outside without earphones. I can't swim in my pool without earphones in. It's madness. Let him blast. Let's get it over with. If you have a problem, get pre-blast surveys. Let's have all of our wells tested. And then we can make a direct line back to him. You did this, you owe us X, Y, and Z. You now have to fix any problems that you caused from your blasting. Okay. And that's all I have to say.
Very good. Thank you, Janet. Last four, 5, 4, 7, 8. Do you have anything you'd like to say? Yep, 5, 4, 7, 8.
I'm not sure if that's me or not.
Yeah, I believe.
Because I'm in on my iPad, Patricia.
Okay, yeah, it's
Are you okay with me speaking now?
Yes, go ahead, Patricia.
Okay, I'm Patricia Bannock. I'm speaking on behalf of myself and my husband. We've lived at 104 Green Tree Lane in Summers for 37 years. We're down the mountain from the Eastman property. My objection is that this is essentially, in my opinion, a quarry operation. The jackhammering goes on incessantly. I don't find any exceptional difficulty or unusual hardship to the Eastmans by the fact that they wouldn't be able to build a play area for the children, build a barn or gazebo, or create stone walls, which are some of the examples that were given in the application. If I heard correctly at the beginning of the hearing, they've been at the property for since 2005. Is that correct?
Yes, I believe so.
15 years later, they decide they have this hardship. To me, that's not a hardship. Also, I don't find anything unique about the property in that I live abutting to ledge. It's about 10 feet from the back of my house. I have no backyard. When I wanted to expand my kitchen, I had an architect who drew a plan that would have forced us to blast ledge. And we realized that there were other ways to do this. So I object to the noise. It's constant. We're down on 104 Green Tree. We take walks 2 miles from here. We walk down to Heron Pond, and we can still hear it. We've talked to neighbor on Rosehaven. They can hear it. We've been listening to it for months. I also think that if you issue a cease and desist order, there should be a penalty for violating it. I think it's absurd to interpret it as cease and desist or appeal. I think that's disingenuous, totally disingenuous. So I object strenuously to granting an appeal. And I think there should be penalties invoked for the 2 months that they've been doing this. In fact, I was up on the street today, and I took a sound clip of the jackhammering. And I know they were jackhammering the week of May 25th, and they've been jackhammering all along. So I support the zoning board of appeals in their cease and desist order, and I think it should be enforced strenuously. Thank you.
Very good, thank you. Before we go on, I just want to make a point that our job here tonight is to either support or remove the cease and desist and possibly grant the variances. We are not in a position to do any enforcement or apply any penalties or anything of that nature, so that point has been made. We are aware of it, and so if we could move on past that, and let's try and keep the, get yourself on the record. Again, as I said, if it's a point that's been made before, just say that you concur on these short points. If you have something new to say, we do want to hear it. So let us continue. If your phone number is ending in 8969, do you have anything to say?
Yes, can you hear me now?
I can hear you now.
This is Sandy Olersic at 47 Long Hill Drive. I'm making this statement on behalf of myself and my husband, and I strongly urge the Zoning Board of Appeals to deny Amy Eastman's appeal and any variance related thereto, and to uphold the town's cease and desist orders for the properties located at 40 and 42 Holly Lane in Summers. The stated purposes of the Town of Summers zoning regulations outlined in Section 214-1 are to protect and promote the public health, safety, welfare, convenience, and property values, to conserve and protect existing and potential surface water and groundwater drinking supplies and other valuable natural resources, and to prevent unnecessary soil erosion and sedimentation. Allowing the continued jackhammering and extensive excavation on these properties is contrary to Summers zoning regulations, and likely already has and will continue to have an adverse impact on the public health of surrounding property owners, including potentially negatively impacting groundwater in the surrounding neighborhood, potentially causing unnecessary soil erosion and sedimentation, and potentially negatively impacting property values, all of which are an express contradiction to the rationale for the Summers zoning regulations. In considering the matter at hand, the Zoning Board of Appeals needs to understand the overall scope of the work performed previously on the parcels and the amount of procedural and legal wrangling that has occurred through both the town and state court systems concerning the work undertaken on these properties. As you know, the properties are in two different residential zones with different regulations. The work on these parcels has been ongoing for years. Over the past several years, the land has been logged, has been subject to extensive blasting. We're talking thousands of cubic yards of rock, mostly without approval, and the work on these parcels has been the subject of special use permit filings that are then withdrawn for procedural or other reasons by the applicant at the last minute. There have been planning commission meetings, zoning commission meetings, many of which were canceled at the last minute, frustrating fed-up neighbors, 2 cease and desist orders issued by the town, which the applicant has failed to comply with by continuing to work while the cease and desist orders are in effect, and 2 legal proceedings initiated by the town in the Judicial District of Tolland at Rockville in an attempt to enforce the cease and desist orders. On several occasions, the applicant has also refused access to her property for inspection by the town. And now here we are again. The difference is that now the ZBA has the opportunity to do the right thing and finally stop this unauthorized activity for once and for all. The site plan that J.R. Russo and Associates prepared indicates that the area of material to be removed is over 1.1 plus or minus acres. We're talking overall acres of material that have been cleared or opened up, blasted, and leveled. In a recent court filing, the applicant's husband admitted to jackhammering the rock outcropping for different periods over 3 years. He did not, however, mention the extensive blasting conducted by these state blasting. Additionally, the applicant has seemingly made deals with several neighbors so that they can excavate, fill, and grade property within 10 feet and 30 feet of adjacent parcels, while the regulations generally do not allow this to occur so close to an adjacent property tract. The surveyor's map also indicates the installation of silt fences. Do we know if proper permits for sedimentation control have been issued? DEEP has guidelines on this when there are soil disturbances of 1 acre or more. It is also my understanding that the applicant has created an extremely large rock wall we're talking maybe 30 to 40 feet high, using the excavated material without any type of engineering or permit. We're not talking about the typical ones and types of stone walls you see in many bucolic areas of the state. We're talking about a massive rock wall that has the potential to fall and damage neighbors or neighboring property if not constructed properly. We have been property owners in Summers for 6 years. Prior to the time we purchased our home in 2014, we conducted well water testing, and while there was some radon in the water, it was below the actionable level of 5,000 picocuries per liter. Additionally, testing revealed we had hard water, though there was no indication that we needed a water softening or mitigation system at that time. After a number of concerns were raised by neighbors about changes in water quality in our neighborhood, and by neighborhood I'm talking about Long Hill Drive, Amy, and Hallie, those seemed to arise after extensive blasting and excavation by the applicant. We had our water retested in September 2019. The same lab conducted the testing in 2014 and 2019. Our water hardness and radon and water numbers have increased dramatically. We also found that we have uranium in our water, something that we and most homeowners did not test for back in 2014. While we have not yet taken steps to prove the causation of these water quality changes, one of the initial assumptions made by a trained professional reviewing the matter is that the prior unauthorized, extensive, and unpermitted blasting and excavation done on the two properties since 2018 have contributed to the dramatic change in the water quality. Specifically, after contacting the State of Connecticut Department of Public Health Well Water Program, officials at the State of Connecticut's Department of Energy and Environmental Protection, as well as an area well water company, we were advised that while radon and water can fluctuate over time and during different seasons, our dramatic increase in radon, which is over 2.5 times the amount at the time of our property purchase, coupled with a 38% increase in water hardness as compared to 2014, were not natural fluctuations and pointed to man-made or artificial causes. We then discussed that there was a large amount of blasting and excavation in the neighborhood, which the department officials stated could have led to new fissures being opened up in the rock, impacting where and over what type of rock the groundwater was traveling, and potentially releasing additional naturally occurring radon and uranium from the bedrock into the water. I know that someone who just spoke, Janet Schlafstein, mentioned that she had a pre-blasting engineering firm. We never had that opportunity to do that prior to all of the blasting. As a result of the reduced water quality, we've now paid thousands of dollars to improve the safety and quality of our well water in order to protect not only our family's health from the potentially adverse effects of these contaminants, but also to protect our home's plumbing and appliances from the detrimental effects of our now very hard well water. And from talking with other neighbors, we are not the only ones who have faced the deterioration of well water quality and have had to install a water treatment and mitigation system, or who are looking into installing such a system. Candidly, the high number of water quality issues that abound in our neighborhood create another worry. As news spreads of the water quality issues in the neighborhood, there could be negative impacts and effects on property values. In addition to the foregoing reasons, the applicant states the work will improve the property and enhance values in the area. The applicant offers no proof of how values in the area will be increased. As previously explained, the work easement to make economic use of her residential properties. I'm not sure what this means, but a residential property is not a commercial venture, and making economic use of it is not something that the town should be concerned with. Further, in its appeal, the applicant provides an affidavit from James E. Ussery Jr., who I believe spoke this evening. It should be noted that said applicant currently works for J.R. Russo and Associates, LLC, and has been paid by the applicant to develop site surveying plans for these properties. On its face, the applicant's employment creates potential conflict of interest. I believe that Attorney Ziska did very well in talking about some of the cases, the legal cases that were noted in Dwight Merriam's memorandum. I was just going to say that I agreed that they cited West Hartford v. Rochelle, and that had to do with challenging estoppel and work by a zoning commission. Even if the town is found to have failed to enforce its zoning ordinances in prior cases, it is long-established law in Connecticut that it's permitted to do so after a lapse. The only other thing I wanted to mention is that at some point there was a letter given by the Eastmans and put in all the neighborhood mailboxes saying that they are just vigorously defending their right to landscape their property. Per the letter, bluntly speaking, under no means can what the applicant is doing be considered landscaping. The applicant is literally trying to effect a wholesale change in the topography of the land by removing a large natural stone feature. In previous correspondence related to 4042 Helly Lane, the rock was described as being 200 feet high, 200 feet long, and 20 feet high. Unfortunately, the town's regulations do not expressly define landscaping, but we can find a definition of landscaping that most people can agree with, which is to modify or ornament a natural landscape by altering the plant cover or to engage in landscape gardening, which is what the dictionary calls it. Most reasonable people would most likely concur that landscaping means planting grass, flowers, shrubs, and trees, and not engaging in weeks or months or blasting or jackhammering to remove a naturally occurring feature of a property that they chose to buy. I think that portion of the property they chose to buy well after they had moved onto the land, so they knew what they were purchasing. For the reasons mentioned, we strongly urge the ZBA to deny Amy Eastman's appeal and any variance related thereto, and to uphold the town's cease and desist orders, as it is in the best interest of Summers to protect the town's residents from further well water issues that could develop due to the previous unauthorized blasting and continued jackhammering and excavation, to avoid soil erosion and to not be contrary to Summers' zoning regulations stated purposes. In the event that such variance is granted, we respectfully request that you limit the hours of jackhammering due to the noise and disruption. Thank you very much for your attention to this.
Thank you, Sandy. Okay, we're moving on to phone number ending in 7894. Do you have anything to add? Okay, phone number ending in 7650. Do you have anything to add?
Yes, this is Kathy Welch. My address is 168 Mountain Road. My husband Timothy is here with me, and we are both in agreement. We would like to support the cease and desist, and we're against any applications for variances for this property. Our property is not abutting, but it is directly across the road from the dirt driveway that goes up to the property in question, and so we get a lot of traffic through there, as well as the the bouncing of the ledge that's underneath the road. Even when snowplows go by, the road bounces somewhat, and with these heavy trucks with stuff in them, it makes it even more bouncy. There's a ledge there. With blasting, we've already had damage. Our house is a stone house, and it's not built like a stick-built house where, there's give and take. There is no give and take in a stone house. We've had damage, and I've documented that damage and sent it on to Jennifer Roy, who I believe has shared it with, I'm not sure if it's both the zoning and the zoning board of appeals, but it was sent to her. So anyway, we are in complete agreement with Sandy, the lady that just spoke, and thank you for letting us speak.
Thank you, Kathy. Okay, we're moving on to phone number ending in 2558. Do you have anything to add? It's 2558. Okay, that's a no. Moving on, phone number ending in 3378. Do you have anything you'd like to add? 3378.
There you go.
Hello?
Nothing to add.
Okay, thank you. Phone number ending in 5478. Do you have anything you'd like to add? Oops, no, 5141. Nope. 5141. Yep. Hello.
No, thank you.
Anything to add? That's a no. Jen, is it Greiger or Grieger?
It doesn't matter how it's pronounced, Rigger, but it doesn't matter. So Attorney Siska and Sandy, actually everybody that's been speaking, I was able to cross off at least probably 5 or so minutes of speaking.
Your address, please, Jen?
24 Amy Lane.
Thank you.
So as a part of preparing for this meeting, I've tried to educate myself on town regulations, spent time gathering information in order to protect my family from the harmful effects of the activity that has been occurring just 2 houses away from me. Tonight's about whether or not the property owners of 40 and 42 Holly Lane have violated the cease and desist issued both in July 2019 and April 2020. Yes, and yes, they have been for over 3 years. There are no permits, nor have there ever been, for any work involving a significant amount of blasting, excavation, and filling on both 42 and 40 Holly Lane that we believe to be at least 50,000 cubic yards to date. Mr. Park argues that this single-family residential use property constitutes an exceptional difficulty or unusual hardship due to the outcrop of rock that precludes the orderly development of the lot for the creation of a play area for their 10 children. As definitions were made a part of this appeal, so too can synonyms. For clarification, play area synonyms found include grass, lawn, and yard. This property was purchased and split from 110 Long Hill in 2009 and was then created as 42 Holly Lane by the Eastmans. The land was not originally intended to be a separate residential property when the neighborhood was developed due to the difficulties of developing the space and costs associated with it. This information is in the office of the developer. The 42 Holly Lane property has no frontage and is non-conforming for a residential dwelling, nor should it be considered as a yard for 40 Holly Lane property is clearly stated by Regulations 214.11. They state frontage of lot used for residential purposes, yards, and open space. A, no lot shall be occupied for residential purposes unless it has the required frontage in the applicable zone on a town-approved or state-approved street. B, no yard or other open space on a lot shall be considered as a yard or other open space on any other lot. Additionally, 214.8 lot frontage states, no building or zoning permit shall be issued for any building, structure, or land use unless the lot for which the permit is sought has the required frontage on either a town-approved or state-approved street or street under construction which shall have been approved by the Planning Commission and complies with the frontage requirements stated in Article 17 of these regulations. It does not appear 42 Holly Lane can be used for a single-family dwelling nor a yard for 40 Holly Lane, and should not be issued a permit due to lack of frontage. Now that it has been split and made into a new lot, this creation by the Eastmans is non-conforming as the town regulations seem to state. As Mr. Parks states in his appeal, Eastmans did not create the exceptional difficulty or unusual hardship referring to the outcrop of rock. True is that rock has been there for millions of years. The Eastmans did, however, appear to have created their own practical difficulty or particular hardship of acquiring the land that is landlocked and inferring that it's a buildable lot or to be used as a yard. In researching what exactly this meant, I found this particular statement explaining that made sense to me. Courts have ruled that practical difficulty or particular hardship cannot be self-created, cannot be just showing that the property would be worth more if a variation were granted, and it cannot be just a demonstration that a property is better suited for a use that is prohibited than a use that is permitted. Connecticut General Statute 8.6 allows ZBA to grant variances from zoning bylaws, ordinances, or regulations. In making its decision, the ZBA must consider public health, safety, convenience, welfare, and property values. The applicant must show that the variance will not substantially affect the municipality's comprehensive zoning plan. Nothing in the appeal shows proof that any variance will not affect public health, safety, convenience, welfare, property values that I have found in any of the past or present files. No traffic reports, no noise testing, no radon or uranium reports associated with blasting and heavy excavation, nor permits can be found for the magnitude of excavating, removal, or fill for both A and A1 zones in the public files for the past 3 years. You'll find a significant record of noise complaints from the area or from around the area that extend beyond the neighbors and the butters that are also affected by this. Mr. Heavey at the Trooper Barracks can be contacted for more information. Mr. Park's appeal states the property owner wants to break up the rock outcropping by mechanical means. No blasting will be used. Again, Had any of the public hearings taken place or correspondence been provided to the ZBA for the past year, you would find, one, that the property has already had 5 weeks of blasting and 7 months of excavation in 2018, as the neighborhood and abutters have all reported both to the town in 2018 as well as June 2019 public hearing. The estimated amount of cubic yards is between 25,000 and 30,000. In May 2019, the zoning board approved 1,000 cubic yards of blasting after the blasting company representative stated that he'd already drilled and loaded the area with explosives without proper permitting for the proposed 12,000 cubic yards. It does not appear from the recorded meetings that the zoning board was made aware of the 5 weeks of blasting and the 6 to 7 months of excavation on the site already. A few days later, it was discovered by neighbors that no permits for blasting existed for 2018, as was claimed by the property owner. Excavation accelerated after the Eastman's Council rescinded their application for a special use permit in July of 2019. A cease and desist was issued for 40 and 42 Halley Lane on July 14th, 2019, for which they did not comply and continued to excavate through November. Eastman's attorney did not allow for public hearings for both zoning and ZBA to take place in 2019 and 2020 by applying for and rescinding applications which appeared to manipulate the system and allowed for more unpermitted work to continue without allowing site inspections, to my knowledge. It was quiet from November 2019 to mid-April 2020, then heavy equipment return and the jackhammering commenced every morning beginning at 7 a.m. and stopping at 6 p.m., Monday through Saturday, that includes up to today. The property owner appears to acknowledge in a hand-delivered letter to neighbors 2 weeks ago that they are in fact continuing to work despite a cease and desist, and they do not believe they require a special use permit on private property. He asked that the neighbors give him permission to blast, to make the project, a project with no end date or plan, go faster and be quieter, recognizing how incredibly loud and disruptive it is for everyone. He also appears to dismiss neighbors' lab reports of increased levels of uranium and radon that now require mitigation with no proof or evaluations by experts of his own to back up the statement. June 2nd, an injunction was granted by the Hartford court system. Mr. Park states in his appeal that he requests the ZBA determine the zoning regulations are in harmony with their general purpose and intent and with due consideration for conserving the public health, safety, convenience, welfare, and property values, and the public safety and welfare is secured. I'm not sure what the last statement means. Is he indicating that the public safety and welfare that we all have been saying are at risk will suddenly not be if you permit the same activity that has been unpermitted all this time? What Mr. Parks has not been saying in his appeal is that Mr. Jacobs, the town sanitarian, recommended back in January at the Planning Commission meeting for pre-post well testing for uranium and radon that is a concern with blasting. Many of the neighbors have also spoken with Department of Energy and Environmental Protections and Connecticut Public Health Department, and they highly recommended private well testing that is part of pre-post testing for structures and surrounding wells whenever there is blasting heavy excavation. We were denied this opportunity to pre-test before the 5 weeks of blasting in 2018 that the property owner advised some neighbors was properly permitted. Neighbors did find high levels of uranium and or radon require mitigation costing $6,000 for uranium mitigation and as much as $11,000 for both radon and uranium. That was not an issue in purchasing our homes prior to the 2018 blasting. DEEP and Connecticut Public Health recommendations is retesting 6 months post-blasting excavation and annually until stabilization. And we continue to be denied the opportunity to retest with the ongoing work. All of this work has been unpermitted, uninspected by the town, as the property owner refuses to allow site inspections by the zoning enforcement that we are aware of. Is Mr. Parks and the property owner and any of their other attorneys requiring a cluster of cancer or lung and kidney disease diagnoses directly related to uranium and or radon as demonstrative proof or of irreparable injury? Because that's how the high levels of uranium and radon can affect the human body, as DEEP Connecticut Public Health have stated. There's also an immense body of research online for anyone to read and educate themselves as to the possible effects of radon and uranium, if not mitigated. And I wanted to just give you a little, I was going to talk about something else, but let me play something for you just so you get an understanding of what we have to put up with every single day.
Jen, I think we've made your point. I think we'd like to...
Oh, I'm not done. You should hear this, though, if I can get it to go. Shit. Oops, excuse me. I can't get it to go. Anyway, so obviously there's noise constantly. There's an issue with, I'll try to paraphrase some of these things to make it a little shorter, but property values have significantly dropped in the neighborhood, with several in the last year selling for significantly less than market value. You can view this information online. I'm just perusing here to see what I can omit. Nothing was said in the appeal of the topsoil that would need to be brought in for the yard that Mr. Eastman and Mr. Usry reported at the planning meeting on January 9th, 2020. You can go online. In this, Mr. Eastman states he wants to plant grass, again confirming a yard. Mr. Eastman states there's an existing logging road that will bring up topsoil in order to plant the grass. I believe it was the chair of the planning commission asking about the contractor using his 7 to 9 cubic yard triaxle and estimating 1,350 trips up and down this logging road that's still in question as to proper permitting. Nothing was discussed as to where this rock broken up on 40 Holly Lane would be transported to, but I think it's presumed it would be relocated to 42 Holly Lane, an A zone which does not allow for this. I will skip over the part I was going to talk about with Mr. Miriam, since the attorneys just covered all of this. Mr. Park and his opinions and affidavits are all an attempt to legitimize a massive amount of work that has gone unpermitted, uninspected, or regulated for several years. The ZBA is being charged with a decision as to whether the property owner's rights are being violated, if town regulations are valid and enforceable, as well as all the 50-plus neighbors' rights as well. Mr. Park's apparent attempt to substantially affect the municipality's comprehensive zoning plan, in essence, is asking you, the ZBA, to violate the Connecticut General Statute 8-6. Such approval will have lasting repercussions, and the inability for the town of Somerville to ever enforce any type of regulation simply by pulling out a dictionary and distorting the facts. And lastly, Town Regulations 21434, illegal use, states nothing in these regulations shall be interpreted as authorization for or approval of the continuation of any use of land, building, structure, or premises which, when commenced or first established, was in violation of the zoning regulations then in effect, and which have never subsequently been legally validated by any amendment to such regulations or by any provision of state law. I oppose any variances, and I feel the cease and desist must be upheld, and I'll leave it at that.
Very good, thank you, Jen. Erica Purdy?
Secretary, reporter.
Yeah, I don't have anything to say. I'm just here to report on this.
Okay, thank you. Dwight Merriam?
Good evening.
Good evening.
My name is Dwight Merriam. I'm a lawyer in private practice with offices at 80 Latimer Lane in Simsbury. And I was retained by John Parks initially, and later the Eastmans. And I was asked to give an opinion on whether the special use permit requirements applied to 40 and 42 Halley Lane. And like Attorney Ziska, I was given free rein to investigate and make my own independent opinion. And I said I would do that before agreeing to be retained to assist. And I did that research, and I reached the opinion I did, that the special use permits do not apply to this operation. I appreciate Attorney Ziska's, shall I say, spirited critique of my opinion. I regret some of the things he had to say about me, but I want to walk you through my thought process more quickly than he was able to present what he had to say. I would say, as an aside, this is not a quarrying operation. That is so far from what it is. But here's what I did. I looked at the regulations, and it says excavation, removal, and filling. So, what does that mean? So, I looked in the definition sections of the regulations. The words aren't there. There's no definition of excavation. There's no definition of removal. There's no definition of filling. So then I looked at the case law. Now, Attorney Ziska told you a little something about his background. I happen to be the co-editor of the leading treatise in my field, Rathkoff's Law of Zoning and Planning. My co-author is Professor Sarah Bronin of UConn Law School. I have a master's in planning from the University of North Carolina. I've been a president of the American Institute of Certified Planners, a fellow of the American Institute. I have a law degree from Yale. I practiced for 40 years at Robinson and Cole until I retired there at age 70. I know something about the literature. I also co-editor of the only book on the subject of development definitions in the country. So I went to the treatises, my own treatise, and I went to my own development definitions book, and I went to the dictionaries, and yes, that is my family, and I went to the case law. Now, there's practically no, and none of that was all very helpful. The dictionary definitions are, Attorney Ziska takes bits and pieces of them. It's not getting us to where we need to go. So I still didn't know at that point, what does it mean, excavation, removal, and filling? So, as I said, I went to the case law. One of the things that's so interesting about the case law here, when I looked, for example, on later on variances, I couldn't find hardly any variance cases on rocks. I taught land use law for 40 years in various law schools, UConn, Quinnipiac, University of Vermont, Vermont Law School 14 years, Bridgeport, when it was Bridgeport, before it came up here and became Quinnipiac. And the variance case that I use in teaching land use law to law students is the rock outcrop. It's the classic example of the appropriate variance, because it's an existing condition, it's impediment on the reasonable use of property, and it's not self-created, and it's unique to a particular property. So anyway, so there I was, still not knowing what an excavation, removal, or filling was. So I asked, what do people do in this town? What are the applications like? Who's got the most experience in town? And they said, well, Patrice Carson does. And Jay, who is Eastman's engineer, probably does more subdivisions and lots than anybody in town. I said, what do they say? Have you read their affidavits, their sworn statements? Those are sworn statements. Okay? Subjection to perjury if they're not true. The idea that Jay Usury has some conflict of interest is really unacceptable. Those are sworn affidavits. And they document scores of instances where individual residential lot owners did this type of excavation, removal in terms of picking it up and moving it around on the property, and regrading with it, without removing it, without being subject to the special use permit. In fact, tonight in this record, there isn't a single case that I know of that's reflected here by the town of a special use permit for a residential property owner not removing the material from the site. Because that part of the regulations is designed solely for commercial operations. And what upset, I think, the zoning enforcement people, you got a wonderful zoning enforcement officer, you got a great town attorney, and I respect and understand his opinion too, but I understand also why he reached his opinion when he did back in February, because he didn't have Patrice Carson's affidavit. and he didn't have Jay Ussery's affidavit. And he didn't know that the pattern and practice in the town of Summers for decades has been that the special use permit is only used for commercial operations. And so I reached the conclusion, and there was a whole lot of how many angels dancing on the head of a pin, where Attorney Ziska goes for the most part, of this part and that part and so forth. But the bottom line for me in the end was the pattern and practice of the town interpreting its own regulations, the zoning commission and the zoning enforcement officer, was that excavation, removal, and filling meant commercial operations and taking material off-site for sale for profit. So that's why I concluded that the special use permit didn't apply. And that's when I said to John Parks, you know, maybe you shouldn't have these applications in there because you don't need them. And that's when he pulled them. That's the explanation for that. And that's where we stand now. So you have before you an appeal of the cease and desist orders and a request that you lift those cease and desist orders. And I believe you're compelled to do so, because the way the town has defined its own special use permit regulations as being limited solely to commercial operations. But I also know that your interest is in protecting these neighbors who spoke out tonight, protecting the town's interest and the like. And that's why I recommended to John Parks and to Amy Eastman, the property owner, and to her husband Dan, a set of conditions that you could impose in this process, and that you should have those conditions in hand. And they include hours of operation. They include, and you've probably never seen this or done this before, but it's exactly what I think you ought to do. And that is, the Eastmans will pay for a third-party engineer. The town will pick the engineer. The Eastmans will pay for it. The engineer will act independently. The engineer will oversee the remaining work to be done and will report directly to the town and to the neighbors and to the Eastmans to make sure that the soil erosion and sedimentation controls are in place and properly managed, and that there is no off-site impact from that. And in addition, as John Parks alluded to, one of those conditions in writing to you tonight is that the Amy Eastman be required to put up a $100,000 cash letter of credit bond to pay for any remediation of well damage. There won't be any well damage. We're assured by consultants that we're not the cause of problems that people may be having, and we won't cause problems in the future. We hired an acoustics engineer and asked him, what would you do? And he said, you know, I think you'd be a lot better off doing blasting than jackhammering. The reason why there's jackhammering here is related to me, was that the town officials told the fire marshal he could not issue a permit for further blasting because they didn't have zoning approval. Okay. But blasting is a concussive shock into the ground rather than noise into the air. It takes half the time that the jackhammering will. It'll be over in less than 2 months. The status of the project is, Jay, just to summarize, is that on 42, nearly all of it's done. There's less than 1,000 yards. So in the alternative, you have the power to grant variances with these conditions as well. And those 42 requires, the only reason why there's a request for a variance, John Parks didn't get to explain it at the end, for the additional rock breakup, is just so it's clear that there isn't going to be an attempt to try to restore 42 to some prior condition. It's impossible, technically impossible. So really, maybe a variance isn't needed there at all, but it is a good idea to document once and for all that the material that's there can simply stay there as it is. On the family's house lot, you know, it's 5+ acres. There's about 9,630 cubic yards of rock that has to be removed. The only one who's really affected by it is the Eastmans themselves. And they can get by with a variance just of the 1,000-yard exemption from the special use permit requirements. Yes. Carl Landolina said, to John Parks, why don't you just apply for a special use permit? Well, number one, our position is it doesn't apply because it's a single-family lot. They're keeping it on their property. We don't think the special use permit applies. We don't want to litigate that issue, but we're quite confident of our position that it simply doesn't apply based on those affidavits, which are compelling. But regardless, there is this 1,000 cubic yard exception, which allows anybody with less than 1,000 yards in a zone that allows a special use permit to not have to apply for a special use permit. So the easiest way to get past that is to grant a variance for the 9,630 cubic yards. If there were 3 or 4 lots on there, they'd have 3,000 or 4,000 yards already. I was the one who recommended that they jointly come in with an appeal of the cease and desist orders and the variance request. And it's a technique that I've used representing commissions and boards and representing property owners as well. And the advantage of it to you and to the town and to the neighbors who will benefit by the conditions that the easements propose is that if you don't want to be in a situation where you're raising questions about the ordinance, then you can pass on the cease and desist and go to the variances. I think, however, with regard to the cease and desist orders, and I'll end with this because it's really all I need to tell you about the basics of the issues that I looked at, is that these affidavits of Patrice Carson and Jay Ussery are dispositive. The excavation, removal, and filling regulations only apply to commercial operations. Maybe the regulations need some amendment. That's not your job, it's not my job, but my opinion is that it simply doesn't apply where the material is being kept on sites, not done for profit. And now we have, with these conditions, the ability to lift those cease and desist orders, impose the conditions, protect the surrounding property owners. If the jackhammering continues, it's going to be 3 months plus. If blasting is allowed, it'll be done in less than 2 months. I think more like 6 weeks. 2 months is a safe window. They'll be all done, they'll be out, it'll be over, it'll be behind us all. I won't go into more details in my opinion, it speaks for itself. And I won't spend your time to rebut point by point where I disagree with Attorney Ziska, but reasonable, good lawyers could disagree, and we've got 3 good lawyers on 3 different positions here. That's just the way these things turn out. So I'm open to any questions. I think that Dan Eastman may want to speak too, and I know that John wants to wrap up. I appreciate your listening to me. It's an interesting case. It's an interesting case for the neighbors, for the town, for the Eastmans. I really don't like to see this conflict. I would like to see this resolved quickly to the satisfaction of all concerned. The denial of the appeals on the cease and desist and the denial of the variances is not going to be the last chapter written in this story, unfortunately. And I think we all owe it to all of the stakeholders to find a path forward that will resolve it, and hopefully here tonight. So thank you for your attention.
Thank you, Dwight. Let's see, we'll move on to Fred Thompson.
I concur with Pat Brockway. Thank you.
You concurred with who? I'm sorry, Fred?
Oh, he muted himself.
Pat Brockway? Might have said the name wrong. I'm at 54 Green Tree Lane.
You Pat Bannock?
Sorry, yes, Pat. Great.
Okay,
Sorry.
thank you.
I'm getting confused.
Just iPhone.
We have an All right, let's go to,
That's all, thank you.
okay, thank you. We'll go to Vicky Clark.
Hi, can you hear me okay?
Yes.
Okay, it's Tom Clark, and Vicky's with me as well. Thank you so much for allowing us to speak. I'm going to try to keep this as short and sweet as possible. I'm actually listening to other people talking, and some of the information they brought forward, I'm going to try to omit from mine, so just bear with me a little bit. Good evening. We are Tom and Vicki Clark. We reside at 175 Mountain Road. We are here tonight to discuss with you our continued concern and objection to the ongoing work at 40 Halley Lane and 42 Halley Lane, and support the cease and desist and any variance order as issued by the Summer Zoning Enforcement Office, and as an abutter to express our objections to requested variance. We have prepared statements so many times in this topic over the years. While it is the applicant's right and possible legal strategy, they seem to withdraw the request at almost every public hearing. We want to be clear, we have not voiced any of this in any settings that are not appropriate. We have not discussed this on social media. We have refused requests from news media for interviews, and we have followed the proper channels to be as respectful to the system, the process, and the town as possible. While we remain respectful, we listen every single day, not only to the incessant commercial jackhammering, excavators, and front loaders moving tons of ledge or rock outcrop from behind our house. We also witness commercial vehicles, to include fuel trucks and private vehicles, on a nearly daily basis, navigating an access road which has a significant uphill grade, and which we strongly feel has yet to be proven legal, and to our knowledge is not permitted or approved by the town. It is clearly being used as a commercial trucking road. There's a long history associated with this, and I'm just going to kind of briefly go through that. I'm going to bypass that because it's already been taken care of. But because we were unable to interface in person and look at a map together, we felt it was important to further explain this construction road. We've been told in the past that there were permits mostly for the creation of the road that crossed the easement over 110 Long Hill to access 42 Halley Lane. To date, we've been unable to find any in the building department file. To give you some history, when we purchased the property in 2009, we walked the property and saw that this access road actually was pretty dense forest, and you could even barely tell it was a road. We had gone down to the town hall and spoke to the former town planner, and we were brought into a room and the maps were pulled out, and we were able to review the maps, and in that effort, it was later determined that the zoning was very restrictive being Zone A because the need to maintain the frontage on the parcel of 110 Longville Road. There was really nothing anybody could do with the land. It could not be built on or developed in any way, as the frontage needs to remain in order for 110 Longville to remain a conforming residential lot, and it would always remain unusable land. It was later determined that the Eastmans had purchased the easement over the same parcel belonging to 110 Longville Road in an effort to connect the land they purchased, which is now known as 42 Halley Lane. Over the years, this strip has been cleared, excavated, jackhammered, compacted, and is used today as the main access road to the work being completed on what is now known as 42 Halley Lane, an A-zone property. What brings us here tonight to the ZBA is an application for a hearing. This appeal submitted by the applicant's attorney, Mr. Parks, on an unknown date in May, as the document does not reference any application number or date which it was submitted. This process in general has been a dog and pony show. Every time the 20 or so affected residents attend to speak at the public hearing, the applicant's attorney withdraw the permit, thus allowing us no opportunity to voice what is actually going on. Clearly, it is a legal prerogative that their attorney can employ as their legal strategy, which for all intents and purposes appears to be a delay while the work is being completed to their satisfaction. There's also been a trend during these proceedings of incomplete or undated documents, applications, incomplete maps, site plans, and other requirements for a project of this magnitude. The work is continued through 2 cease and desist orders with no oversight or adherence to the DEP guidelines, erosion, or even stormwater permits. Mr. Park's argument is that the work that they are trying to do is in harmony with other property uses in the area. But being this is a rural forest part of town, we do not see how the excavation, removal of rock outcropping is even remotely in harmony with the other residential properties in the area. Mr. Parks makes the argument he believes that the work will improve the property and enhance values in the area. But have there been any feasibility studies by any licensed appraisers to be able to substantiate that that's actually an enhanced value to any of the surrounding properties? Frankly, we would think the opposite, not to mention the vast concerns for what the previous excavation and blasting activities have had on our environment, our water table, our well water composition, the radon in the air of our homes, and the natural ridge line. Mr. Parks further makes the claim that this is a lot for a single-family residential use, and that the hardships of the outcropping of rocks came with the land. It is important to note that the applicant made the conscious choice to purchase the land fully knowing that the land contained, in Mr. Parks' explanation, quote, substantial area of rock crop that precludes the orderly development of the lot for its single-family use, end of quote. We can only assume that the rock formations were not deposited there and existed for hundreds, if not thousands of years prior to purchasing the land. Furthermore, the land they purchased that's in the A zone, known as 42 Halley Lane, was essentially a landlocked parcel at the time of purchase when they divided it off 110 Long Hill Road, with the only accessibility to a public road being via the driveway from the single-family home located at 40 Halley Lane. Thus, it appears the applicant created their own hardship when consciously purchasing the property. Further, the assessor's records of 42 Halley Lane do not show this is a single-family residential parcel. It is labeled as forest, which it was for years prior, and can certainly be attested by those who have lived in the surrounding area for many years. We believe it is important to note that the work has been done under pretense of an application or requested special use permit over the last several years, has changed in the modality of removal, but the project itself remains the same. It began as 12,000 cubic yards and then grew into 19,000 cubic yards. Learning of such a monumental endeavor in a residential area, we had to do some research in order to understand how much 12,000 cubic yards would be. Tilcon Connecticut and Company, a leading supplier of crushed rock material in Connecticut, was contacted. Speaking to a representative, we asked for assistance in determining a ballpark figure as to how many truckloads that would require moving an amount of ledge and associated materials. The representative provided us with a calculation which is as follows. 12,000 cubic yards would have to be converted to tons. A factor would also have to be the size of the ledge pieces, which is a variable. With that said, the Tilcon representative indicated that 12,000 cubic yards using a 1.38 conversion would equal 8,695 tons. The representative related that a tri-axle dump truck is limited to approximately 15 tons. However, a super dump can handle up to 26 tons. They used 22 tons as a mean, and using that came up with this figure. It would take 395 tri-axle truckloads to move that material. In 2019, the applicant revised the request to 19,000 cubic yards. Using the same formula, that would equate to 13,768 tons, or 625 truckloads to move that material. It is apparent that the scope of this requested work in a residential zone will be along the lines of the sand and gravel operation in order to effectively clear the property for their desired use. Although the applicant has now related he will not remove the material from the property, he is in fact removing material from the ground using a large excavator with a jackhammer device and taking commercial front loaders to scoop up the broken ledge and deliver said materials throughout his land, creating such a significant amount of noise that could be heard through other parts of the town. That is no exaggeration, and we don't think any reasonable and prudent individual could dispute that. To what extent does this go on, especially considering adverse effects on the neighbors and butters? Mr. Park relates in his argument for this appeal that there would be no impact on the neighborhood from trucks coming in and going to the properties. Can you imagine the ramification of one of these field trucks tipping over the steep grade? The applicant has in fact told us he intends to truck topsoil. We don't think he's going to use his driveway at 40 Halley Lane. If you look at the most recent map submitted to the zoning commission for the last request that was made for 19 cubic yard removal, the applicant's driveway is the only means of ingress and egress, and the road constructed off Mountain Road is not even on the map, yet it is a road that is currently used daily. We understand this is a very difficult situation for town officials to deal with. These are our regulations, all our regulations, not some of ours. Allowing these activities continue unpermitted on land that they are not zoned to be done on simply under the premise that the owner or their attorneys believe they do not need a permit is a very dangerous precedent. The complexity and enormity of this project is uniquely special in a residential zone. If this was a cut and dry, then this would have been resolved a long time ago. When attorneys have to decipher the definition of excavation or removal, then it can be surmised that this project is a stretch of what the regulations intended. There have been other suggestions about this type of work has occurred in the past. However, what's suggested is those individuals bring up subdivisions, which this is clearly not a subdivision. It is a single-family endeavor, or perhaps if they have been, sand and gravel operations that adhere to a multitude of regulations designed to protect the environment, the land, and those who live around it. We want to be crystal clear here. We do not have any personal issue with the applicant. Over the decade plus that we have lived near each other, we've had very little contact with one another, and certainly no issues to dispute with each other. In fact, within the last several months, we personally have had the opportunity to speak with Dan on several occasions. Other than the initial conversation, which was adversarial, our recent conversations have been civil, however direct and poignant. He has related that he is undergoing this project to benefit his family. My contention is, I have been fighting this project for the same reason, quality of life. We obviously agree to disagree on this entire project. I cannot speak for all the affected neighbors, but I'm assuming they feel the same way. It is clearly a quality of life for all of us, and it has been adversely affecting all of us. Unfortunately, especially in the spring and summer months when it is warm out, we collectively as a family have always enjoyed our dinners together outside around 5:30 time frame. Just a time frame we've established as a family for years and years. Since all this has been going on, unfortunately, we have altered our family schedule. We now have to wait till at least 6 o'clock when the contractor's day ends in order to go outside and eat, have some peace and quiet, and enjoy our yard. Frankly, we have over 7 acres, and it constantly feels as though the work is being done right on top of our house. And I know for a fact other neighbors feel the same way. We cannot open our windows and doors when it is warm out because the noise is just overwhelming. This has been the case on and off for several years. When does it end, guys? Why do the needs of one family outweigh the needs of the many surrounding individuals and families? Frankly, it has always been a practice of mine to not even begin to mow my lawn until at least 10 o'clock in the morning on weekends out of respect for my neighbor's tranquility and peacefulness. In my lifetime, I've always made my decisions and taken action after I carefully considered what a reasonable and prudent individual would do in any given situation that I was addressing. In this case, I am certain that the roles reverse in this scenario, and perhaps the attorneys, ZBA commission members, or even Dan and his family was the subject of the noise and constant construction. There is no question in my mind they would be pleading their case before you as well as not being reasonable. We simply have significant concerns over their activities. We believe what they have been doing for years and years simply is not permitted and goes against the regulations that we all have agreed to follow. If this project was approached many years ago in a proper way, the project would have never happened, or would have been done in a different manner that was respectful to the neighbors and followed the same rules everybody has agreed to follow. And it would have been done with proper oversight to the environmental factors, setbacks, and water permits and regulations and standards for a project of this size and scope. Unfortunately, that didn't happen, and that's why we're here today. While the applicant argues that the work is being done in line with past work, we think your decision will set a huge precedent on the future of our community zoning, respect for regulations, and ability to enforce the regulations we have all agreed to abide by. In conclusion, no offense to the attorneys, but other than the attorneys, there are no winners here either way. The 20 or so neighbors have had to endure the ramifications of their actions regarding the blasting, continual jackhammering, commercial noise of excavators and front loaders scraping and moving ledge and other materials. There is no upside to this for anyone to include the Eastmans. The difference here is, it is their choice to do this. It is not the multitude of neighbors' choice to endure this. Yet, we have collectively been forced to do it. In the final analysis, the ZBA will need to look at the reasonableness of the appeal and the work requested. If they determine that moving 19,000 cubic yards in a residential zone, and to be specific, much of that in an A zone is both fitting of the current zoning regulations, then we respectfully ask that the town deems it acceptable that there be a specific definitive stipulations regarding work hours. We also feel there has to be a definitive and reasonable time frame on which this work needs to be completed should be established, monitored, and held accountable. We sincerely hope that whatever decision you make, it will take in consideration those of us who have been enduring this for the last several years. It may be the first time you are hearing it, but this has been pretty nonstop for all these years. If you decide whether the Eastmans have created their own hardship, these are our regulations, which require all of us to abide by. Thank you for your time. We really appreciate it.
Thank you, Tom. We'll move on to Patricia. If we can get her to unmute. Oop.
I've already made my statement previously,
No.
thank you.
Patrice, I'm sorry. My apologies, Patrice. See if we can get her.
I have nothing to add, unless you have questions of me.
Any questions for Patrice? Okay, anybody else?
Phone number ending in 6611. Did you want to speak?
Okay.
All right, 6611 already spoke. That was Kristen Kern.
Very good. All right, Dan, you're up.
Hello, I'm Dan Eastman from 40 Holly Lane in Summers. I have a couple of rebuttals and comments for people. One, this is certainly not a quarry. We are taking the outcropping down to the existing levels of the ground. We're not going into the ground. Currently, we're taking outcropping above down to the existing levels and spreading that soil out, raising those other levels. So you could say we're doing a cut and fill, but this is a giant landscaping operation that we're trying to spread the yard and get 4 acres of grass. Whether it's reasonable or not, I can't tell you, but it's my choice to do it within my rights as a property owner to treat my land how I would like. I'm not, selling off rock. I'm not shipping rock off the property. I have a couple of hearsay impacts on the radon and wells that are certainly not documented, or they're welcome to take me to court. We've offered to put up a cash bond to settle any wells that have been resolved. When I bought this house in 15, the radon levels were 70, where the state requires them to be 4 or below. They're now 0.4 because we had to put a radon system. If you ask Dan Rillier, who built this project, he'll tell you there was radon in everybody's property when he built this 20-something years ago. There are now codes required in the state of Connecticut to put radon systems in when you build a house in ledge. Those are just now new codes. So I didn't put the radon there. I talked to Mike Talbot, who was a soil scientist, that said there is no way you've impacted other people's property, and to Sean Banner from Banner Water that said you didn't cause any problems. So if someone can prove something else, we're willing to set money aside for it. I don't think there's anything that happens. The blast waves, because we're not going into the ground, blast waves moved horizontal, not vertical. We were shearing off the edges. We did seismic tests around some of these properties, and damage starts at 2, we were 0.2. So we did tests and studies of these people's houses around us. So we know that we didn't cause damage because the blast waves were tested, and the results are printed somewhere. And again, I know I'm putting noise, which is effectively, if you had to hear it, if you were riding your car, it's the same noise. Effectively, that's the decibel level that you're hearing at these other properties. We hired a acoustics engineer that came out and did studies. We've told the town you hire an engineer and come and inspect, and we will pay for it. The erosion issue is not an issue because we're taking an outcropping that water's running off of, and we are leveling it and planting grass. So the reduction of erosion is actually gonna happen, not the increase of erosion. So we have done what we feel is a pretty protective of our neighbors. They don't have to like what I'm doing, but I think I'm well within my rights to do it. And that's my spiel. Thank you for your time.
Very good. Thank you, Dan. Is there anybody else?
Can I say something? Can I just ask a question?
Yes.
Okay, Mr. Eastman,
Who is this?
You gotta state your name again, Joseph.
159 Mountain Road.
Okay.
As someone who, the only contact I've had with Mr. Eastman was a letter that was dropped in our mailbox, and a notification of the hearing to get the special use permit back in 2019, June of 2019. But I did, of course, because I've been asking, getting it, did get the cease and desist, the information about the cease and desist and stuff like that. What is your feeling about the fact that you've been ignoring town-issued cease and desists and just continuing to work?
He's not going to answer that, Joe. So we're not going to go down that road. I apologize, but
you're going to ignore something that's very pertinent.
I'm not going to discuss in a public forum.
We're not here to determine his feelings on why he ignored the cease and desist. We're here to determine whether we're going to deny the cease and desist or keep it going. And that's what we're here to discuss.
Okay.
How he feels about
fair.
it. Okay. So, anybody else?
Jen Grigger, I got the, video.
Yeah, Jen, I think we're got quite a good idea.
I don't think you heard this. This is from 7 a.m. until 6 p.m. Is it hard to hear me?
Okay, your point has been made. Thank you, Jen. All right, we are now going to close the session.
Well, I don't know if Mr. Parks has anything he'd like to add.
I have something as well.
Yeah,
Okay,
before we get to this Attorney Landolina, we mentioned conditions. Is that already part of the package? Is that something that you've shared with the commission? Do you have a list of conditions that the applicant is willing to have you
There's
impose
been some
upon him?
general conditions that have been laid out. The bond.
Right, okay,
and,
hours of operation.
It is not a specific plan.
Well, they're very specific.
Yeah.
Well, can I see what you're referring to?
Yes, on the plan, having your end here.
The latest version is part of the record, is what you're...
Is it part of your packet, John?
It is not part of my packet.
Is this the only thing that it is? Like the last? Amiable to conditions of approval?
No,
Don't feel any mention of
okay.
conditions.
Excuse me, Dean?
Yes,
Hey, it's Tom Clark, 175 Mountain Road.
yes.
If you got 1 second, I just want just for clarification, I have a better understanding of the process. Just bear with me, because I'm a little naive to the process, obviously. So after you guys close the public hearing at this juncture, what occurs? Is there a time frame that a decision is made, and will everyone be notified of that time frame? Will it be tonight, or is it gonna be, down the road a little bit? I'm just trying to.
Tom, it's Attorney Landolina speaking. That's something that the commission or the board will discuss upon the closing of the public hearing, whether they're gonna make a decision tonight or at some point in the future.
Carl, I'm sorry, I couldn't hear you too well. What was that again? I'm sorry.
They're gonna decide after they close the public hearing whether they're gonna make a decision tonight or at some point in the future.
Okay, very good. I just trying to understand the process. I appreciate it. Thanks again.
Perhaps, again, for the record, Carl Landolina.
Page 4 is this is the only place that there shows any kind of condition.
Maybe Attorney Diska wants to, address the board while Mr. Parks is looking for whatever he might be looking for. Okay. With your permission, Mr. Chairman.
Yes, that's fine.
Michael Ziska for the record. Just to respond to a few of Attorney Merriam's comments. He said that he thought the affidavits were dispositive, and that's, I think, where we have a fundamental disagreement. If I thought the affidavits were dispositive, I would have agreed with him, but they're not. In order to be dispositive, what you would have to talk about are specific instances where either the zoning enforcement officer, the zoning commission, or the zoning board of appeals looked at a situation that is just like this one, namely the excavation of over 1,000 cubic yards of bedrock on residential property, and made an official decision that that is not covered by the regulation. That is the only kind of history that really matters. You can't say, I've never been aware of the commission approaching this situation like this, because if there's never been a comparable situation where such a decision has had to be made, then there is no history. And so, the thing that concerns me is Attorney Merriam suggested by saying, well, these are sworn statements and they're subject to perjury. There was an implication that we're saying, that I am saying that these are not true. And I'm not saying that. I'm not saying they're not true. They may very well be true. I have no doubt, that Patrice is saying what she thinks and that Mr. Ussery is saying what he thinks. What I'm saying, though, is what they say in the affidavits doesn't answer the question. If you look at it, most of what Patrice Carson and Mr. Ussery are saying in their affidavits is they've dealt with lots and lots of subdivisions in the town, and it's never been applied this way to subdivisions. There's a specific exemption for subdivisions in Section 68. That's why it doesn't have to get applied to subdivision. No, there never were special use permits required for subdivisions because the subdivisions are exempt. The decision about the excavation and how the excavation should be handled is handled in the Planning Commission session on the subdivision, so it doesn't have to go to the Zoning Commission. So if you look at, again, the affidavit, paragraph 18, none of the subdivisions were required to obtain special use permits. 19, 1,000 cubic yards is not a lot of material for most subdivisions. 20, in the 22 years I was the town planner, the Planning Commission never required any developer of a subdivision. 21, the construction of many of the subdivisions. Subdivision. And that's why I'm thinking, it's almost as though they don't understand that there's an exemption there. These are people that are saying they understand the regulations, and they're acting as though they don't know there's an exemption for subdivisions. And that's why I'm saying, with all respect, this is, they may have misunderstood the question or whatever, but the point is there's nothing in here that says I am familiar with a situation where a zoning official of the town of Somers made an official decision that the excavation of more than 1,000 cubic yards of rock on residential property or vacant property does not require a special use permit. If there were such a thing, then that would be the thing to say in the affidavit, to point out all of those specific instances. That's the only thing that really this board would be able to weigh and that a court would be able to weigh. And the other thing I have to say is, if it's so clear that this has been the Zoning Commission's position for so many decades, if it's that clear, then go to the Zoning Commission. Go to the zoning commission with an application for a special use permit and reserve your rights. Say, we don't think we need this special use permit, but the history has been, and you submit the affidavit, say the history of the zoning commission has been that we don't need special use permits, and we'd like you to make that conclusion. If it's so clear, surely the zoning commission would agree.
In answer to Attorney Landolina's question about conditions, I just got a text that they were emailed to Dan and Jen as we were talking by Dwight Merriam.
Tonight?
Yes. While we were here.
I mean, I've heard some generalizations on, bonds and, engineers and other things, but, as far as the variance that's proposed and the package, there is no specific, set of terms that are included within this request for a variance.
Within that email, I don't know if you can...
Jennifer Roy, for the record. I don't have access to my email.
Okay.
And, I'm just looking at, at the application, and there's no, it's not saying that we're going to, if variance is granted, we're going to do this, we're going to do this, we're going to do this, we're going to do this. It's not there, so.
You want me to tell you exactly what it was? I can say
Apparently he got...
4 seconds.
Yeah, be my guest.
Let you hire an engineer at your choice, and I'll pay for him.
Mm-hmm.
Hours of sorry. Dan Eastman, 40 Holly Lane. Hire an engineer, report directly to you, to the neighbors if they choose, and to me, but you pick the engineer and I'll pay for him to follow the erosion control and all those other laws and impact laws. Put a $100,000 cash bond up or letter of credit, so if someone decides that we've impacted the well and they take us to court, the money's sitting there for them to recover the award. It won't be just frivolous, but if they prove it, the money will be sitting there. Change the hours of operation from to 5:30, from 7 to 5:30 every day and 7 to 3 on Saturday, and get the permission to do blasting to shorten the time frame. We've talked about converting the lots to one lot, so that's something that we're going to work on in the next month, but that's not relevant to our conversation. But those are the terms and conditions, and if you guys had any other stipulations specifically, we would certainly listen to something reasonable. But the noise is exempt from commercial activity, from construction activity, so just realize that the noise exemption, and we did hire an acoustic engineer that will talk to your guy, and he'll assure you that we're within the parameters that's acceptable. So those are, in a nutshell, what I'm assuming that's quasi what you've heard.
Okay.
Thank you.
I just got them on my phone, and I can forward that to somebody else who's not that good at this stuff.
Is it my saying right? That's what it was? Effectively.
Yes, these are just conditions. Hours of operation for jackhammering, Monday through Friday, 7 a.m. to 6 p.m., Saturday, 7 to 5, no work on Sunday.
That's the existing, it's changed. You read further down.
Inspection, zoning enforcement officer may inspect the work.
Dan there.
Hi, Dan.
Have we concluded the public hearing?
We're very close.
John, I think you may want to get closer out.
Well, it's difficult for us here to determine who it is that's speaking.
Okay, I'm sorry. John's coming up now. John Parks is on. That was Dan Thayer. He's a member.
Dan Thayer. John Parks, I'm just reading proposed conditions in the event that the operation was allowed to continue to address some of the neighbors' conditions, the neighbors' concerns.
Attorney, this was a document you distributed just before the start of the meeting?
It was not. It was discussions of ways that the zoning board of appeals could add to whatever decision they make, conditions to, tailor, any decision you make to the specific concerns. And the proposal is to reduce the hours of operation from, what they are currently, not have any operations on Sunday, limit the hours of operation on Saturday to 7 to 3 p.m., and Monday, 7:30 to 5. So the applicant is willing to self-impose that restriction in an effort to reduce the impact on neighbors. The applicant is willing to post a bond, $100,000 bond for any damage to wells caused by any blasting on site. Bond to expire 1 year after completion of blasting, extended until the final judgment in any action taken by the well owner, and used solely to fund a judgment entered in court. The engineer, the independent engineer, I think Dan Eastman stated that correctly, and the condition that the applicant would offer is that the blasting, which would be less noise and quicker, is just one more option, because the most frequent concern I heard was the noise and the persistence of that. So those are the conditions that the applicant would agree to.
Okay, thank you.
Very good. Is anybody else have anything to offer?
I do.
I have a question.
Who's this?
Joseph Bigler, 159 Mountain Road.
Okay, what is it, Joe?
I know, I apologize, but it's important. Accountability, what's to hold him to that?
I'm sorry, what was your question again, Joe? I didn't hear it.
Accountability, everybody's accountable for what they're supposed to do, and the regulations and laws accounted for in this, and Mr. Eastman is now proposing a thing that is a reduction of the thing that he has been doing without any approval. So what accountability would there be to enforce these things, to hold him that to his word, for lack of better terminology, that he would maintain these hours, that he would do this when he has shown a disregard for official issuances from the town?
Okay, the answer to that question is that if we do consider this proposal, if that is the board's wish, then we will address that issue. I don't have the answer for you right this second, but that would definitely be an issue that would be addressed in full.
And I do understand that, and you can understand where my concern with this is, considering that of the, to quote Mr. Clark, the dog and pony show that's been going on throughout the entire process. My concern, of course, is just the continuous thing and the disregard and the history of disregarding.
Okay. Your point is noted. We will try to address that to the best of our ability. Thank you, Joseph. Okay, you're up, Jen.
Okay, Jennifer Roy for the record. I just wanted to point out to the ZBA members in your considerations that the one part of the conditions that they're suggesting for hours of operation does go against the regulation stated hours for in section 214.71 blasting operation standards, and hours D 271D, no activity connected with any excavation, removal, or filling operation may be undertaken on Sunday, which they're doing, or earlier than 7:30 a.m., nor to continue after 5:30 p.m., Monday through Friday, or earlier than 8 a.m. on a Saturday, and nor to continue after noon on Saturday. So just want to point out, they're suggesting 7 to 6, and our regulation states 7:30 to 5:30, and on Saturday, 8 to 12 noon. Well, that's the regulation, I just wanted to point out for the record.
For the record, Carl Landolina, I'm sure people didn't hear Mr. Eastman. I think he said that he would accommodate the hours as set forth in the regulations.
That's right.
Okay.
Thank you. Okay, at this time, we're going to close the...
Can I say one thing?
Who's this?
I'm sorry, it's Tom Clark, 175 Mountain Road.
Yes,
It'll be
Tom.
very brief.
Yep.
Just regarding the hours, I still object to some of these hours. I mean, and again, I understand that Dan's trying to be agreeable on this, and I get that aspect of it. You got to understand something. For years, we've endured a contractor being here from 7 in the morning to sometimes 9 and 10 o'clock at night, 7 days a week. We've endured this for a couple of years. Now they've gotten better with that in regards to the hours recently. But I would hope the board would consider, the commission consider something even more restrictive. Again, like Mr. Parks indicated, there's a lot of noise going on, but there's also truck traffic. There's a lot of other stuff that's actually, we've already talked about, that is consistent with this and has been consistent with this for years. This has been a hardship. I mean, a significant hardship, and I'm not one to complain too much, but frankly, this has been really unreasonable for those of us who've had to endure this, and then there's not just one individual like we indicated. So the hours he suggested, I think, is, it's great, but I think that they should be more restrictive if we can do that, if it comes down to the point where this is agreed upon. So I just want to point that out.
Okay, thank you, Tom.
Thank you very much, Dean. I appreciate it.
Okay, I think we are now ready to close the public hearing and move into the public hearing discussion decisions.
This is Samuel Versick at 47 Long Hill Drive. I was hoping to make one other point in response to Mr. Eastman.
Very good, go ahead.
I just wanted to comment that we were again not given the opportunity to test prior to the blasting from the beginning. So if there was any damage to the well, it's very difficult to prove because we were denied the opportunity to do so. So I just wanted to be on the record for that point.
Very good.
Thank you.
All right, thank you. Okay, now we are going to close the public hearing. Move into the public hearing discussion and decision. I would like to get a motion to grant the appeal of the cease and desist order issued by Jennifer Roy on application number 20-002. And can we do these at the same time, or do they have to be separate?
You need 4 separate motions.
Okay. So
But before you go into that phase, I just want to make sure, it's Attorney Landolina for the record. I want to make sure that, obviously, you do, most of the business that this board does is looking at variances, so you're well aware of the standards, but I want to make sure that everyone is aware of, sections 214.10, which includes the right to vary the regulations, and then the standards under which you can consider and vote on application for variances as set forth in 214.111. There are 4, and I'm not suggesting that you have to make 4 specific findings, but there are 4 elements to the variance application as stated in 214.11A, 1, 2, 3, and 4. I just want to make sure everyone's all familiar with that. Specifically, section 214.11, the opening remarks about use variances and such. You're all familiar with that, I assume?
Mm-hmm.
Yes? Okay. Thank you.
So, may I please get a motion to grant the appeal of the cease and desist order issued by Jennifer Roy on application number 20-002. Anybody?
give you a motion to uphold the cease and desist order.
I'd second that.
Joey with computer audio.
Well, let me just state this for the record before we go through this motion. I always form the motions in the positive, okay? So, in this case, if you're against the override, against the appeal, against granting the appeal, then you would vote in the negative, okay? So it's...
For the record, Carl Landlin, I would suggest that you follow the process that's set forth by the chairman. So, a motion to approve application, which would in fact overturn the cease and desist, would be appropriate, which would require 4 affirmative votes to overturn the decision of the zoning enforcement officer.
Okay, so it has nothing to do with just generally the motions are given in the positive. So I'd like to have a motion.
I'm willing to make the motion to further discussion, as long as I'm not bound necessarily to vote in favor of the motion that I make.
No, you're not.
Oh, absolutely.
You're not bound by, if you make the motion, you're not bound to vote yes on it.
No.
I will make a motion to grant.
We are free to vote however we want. We're just making the motion in the positive. That's just the generally accepted procedure.
So, could you make that motion again, because you were
Yes.
speaking over each other, and for the record?
I would like to get a motion.
Ralph Williams, for the record, I make a motion to grant the appeal of the cease and desist order. Are we making this for separately for the two lots? Or can
So it'll be for 20-002.
Which is which property?
That is 40 Halley Lane, Somers, Connecticut.
Yes. For 40 Halley Lane, so 20-002.
Yep.
I'll second Dan Thayer.
Very good. Discussion.
May I?
You may, Dan. Go ahead.
This has been a long process. We've heard opinions from several attorneys. We've heard compelling comments made from people who live in the area. And the thing that I thought stands out the most is that there was a comment that they had failed to exhaust the administrative remedies well before all of this. That because of that, I don't see this as something that we should be entering into variances for, because zoning hasn't had the opportunity to actually act on this. That's what their purpose is. So, though I second the motion because you like to present them in the affirmative, I have a real problem with doing anything that would in any way change the fact that our zoning enforcement officer issued the cease and desist orders. I think they should be upheld. That's it.
Ralph Williams, for the record. One thing I can agree with Dwight Merriam on is that it's not this board's place to amend the zoning regulations. It's also not this board's place to ignore the zoning regulations. And we do have specifically 214-67, which says no excavation or removal of you take the laundry list of it shall be allowed in any zone without a special use permit. And as Attorney Ziska noted, they did not exhaust their remedies on that score. They withdrew the application. I have to say that although Attorney Parks may disagree with my characterization of it, it would appear that they continue to act in defiance of the cease and desist order while appealing, and I'm not moved. I'm also do not see a hardship here. This is a residential property. It has been a residential property, I assure you, for close on to 40 years, and there's nothing about the character of it that prevents it from being used well as a residential property. For all these reasons, I cannot vote to overturn the cease and desist order.
Anybody else? Joe or Doug? You there, Doug?
Yeah, I'm here.
No, you all set? Anything to add?
No, nothing to add. I'm all set to vote.
Okay, Joe? You with us, Joe? Okay, no audio from Joe.
No. It's connecting to audio now.
Yep. Come on, Joe.
You can do it.
While we're waiting for Joe, I'm going to make my, for the record, I concur with my fellow board members in pretty much everything they said, in that I've always felt that this was a matter that should go before the zoning board for a special use permit, and that we were the wrong body to be in front of. It wasn't our turn yet. That's always, in my opinion, the way I read the regulations, so I concur in that matter, so...
Hi, Dean, this is Joe Marinaccio. For some reason, my audio got disconnected.
Okay.
Having said that, I've been tracking and hearing everything that everyone has said, and I agree with my fellow board members that this does seem like a better ask for forgiveness than permission instance here, and I think that there was some issues with how we got here, and that's what I'll say about that.
Okay. Does anybody else have anything to add? Okay, all in favor of the motion?
Understanding, again, for the record, Carl Andolina, that a yes vote will overturn the decision of the zoning enforcement officer and lift the cease and desist order.
All in favor? Opposed?
Aye. Opposed? Aye.
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 Motion fails, 0-4, it's unanimous.
0 to 5.
0 to 5, excuse me, I'm sorry. I would like to get a motion on application number 20-003, 42 Halley Lane, to overturn the cease and desist order issued by Jennifer Roy.
So moved.
I second. Joe Marinaccio.
Any discussion? All in favor? All opposed?
Aye.
Aye. Motion fails unanimously. I would like to get a motion to grant the variance on number 20-002 for a variance from section 12, earth removal and filling in the summer zoning regulations in the A1 residential zone.
This is for Halley Lane.
If I might, again, for the record, Carl Andolina, if you're going to discuss conditions to be placed upon the granting of, the possible granting of the variance, that should be made part of the motion. I will tell you, with respect to the offered conditions, I really have no opinion on any of them except the one in which the applicant is offered a $100,000 bond to protect the interests, let's say, of the neighbors. As town attorney, I would not want to draft any agreement between private parties. I would not ask the town to hold such funds, be responsible for such funds. So I would suggest that you strongly consider that condition if you're going to impose conditions. The other thing I would suggest is that the applicant has agreed to allow you to impose these conditions. You do have the right under case law and Connecticut law to impose conditions on the granting of a variance. Should you, however, impose conditions which you have not been offered, and the applicant was to disagree about the imposition of those conditions, it would be possible, and you were to grant a variance with those conditions that the applicant found objectionable, the applicant could still take you to court and ask the court to rescind or invalidate those conditions. And you could possibly have, after all that's said and done, a variance granted to someone with no conditions whatsoever, unless you made a specific finding that the only reason you were granting the variance was because the conditions you were imposing were integral to that decision. And therefore, had you not been able to impose those conditions, you would have not have voted for the approval of the variance. So I'd just like to point that out to you. So, I don't know if you want to discuss conditions and make them part of a motion, or you just want to...
I would like to I'd like to put the motion out as I stated, so we can have some discussion. The motion can always be modified, and we can go from there if we do decide to go down that road. I would like to get some discussion on the table first.
So you want a motion simply on a variance, not regarding conditions?
Right.
I will make that motion for 40 Holly Lane.
Very good. Do I have a second?
I'll second Dan Thayer.
Very good. Discussion.
Well, as I said before, I don't see grounds for variance to begin with. I do not see a hardship here. We're talking about, as I said, a house that has been in use for residential use for decades, been in use by this family for a decade and a half. Certainly, they bought it as it was. Unless there's a hardship, and I mean a real hardship, one created by the regulations, I don't see grounds for doing that. So, regardless of conditions, I oppose granting a variance.
Very good. Anybody else?
There, I totally agree with Ralph. We've denied people the ability to widen their driveway because there was no hardship. They bought the house the way it was. This is orders of magnitude more serious, and I don't see any reason that we should approve it at this point.
This is Joe Marinaccio. I agree with that, and it's a little disappointing to hear that, rules weren't followed and the proper procedures were in place for them to go to the zoning board and to begin with. That's what I'll say about that.
Yeah, for me, it's the same thing. I concur that, for all the reasons we didn't grant the overturn of the cease and desist, kind of apply to the trying to grant the variance. We're just not at that stage yet. The ball's not in our court. So, any other discussion? All in favor of the motion? All opposed?
Aye, Dan Thayer. Aye.
Aye. Motion fails unanimously.
Did you clearly hear 5 votes on that?
I didn't hear 5, have them all state their name.
All right, state your name and your vote, please.
7, aye.
You're for or against, Doug?
Against.
Okay.
Dan Thayer. Go ahead, Ralph.
Against.
Dan Thayer, nay.
Joe Marinaccio, against.
Dean Hills, nay. Motion fails unanimously. I would like to get a motion on the table for application number 20-003, asking for a variance from section 12, earth removal and filling in the summer zoning regulations in the A residential zone. A motion to approve. Variance.
Joe Marinaccio, approved.
Second.
Yeah, I'll second that.
Discussion?
Dan Thayer.
Any discussion? All in favor of the motion? Opposed?
Nay.
Dan Thayer, nay.
Ralph Williams, nay.
Doug Stebbins, nay.
Joe Marinaccio, nay.
Dean Hills, nay. Motion fails, 0-5. We're closed on those issues, and correspondence, I did have a couple of pieces of correspondence that were both against the the application. One of them already spoke tonight, that was Pat Benach. The other was Joseph O'Barr of 95 Green Tea Lane.
Question first.
Just, Mr. Hill, I'm sorry, I thought you might have said 20003 again, but I made a mistake.
002 and 003.
Yeah,
It
I
is
thought you did
003.
20003 first.
No, I don't think so. 20.
Oh, okay, you did 02 first, okay, I'm sorry.
Yep.
Apologize.
Hey, Ralph? You there?
Hello?
Ralph?
Yeah?
On the motions for, are you talking about the variance?
Yeah.
On the variance, we did 20002 and then 20003.
We voted, against the variances on both.
Okay, very good. Thank you.
I'm sorry.
No problem. Do I have a motion for adjournment?
So moved, Dan Thayer. Second, Thompson.
All in favor?
Aye.
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 Unanimous. The meeting is adjourned at 10:17.
Good night, guys.
Thank you.
Nice job. Very good.